Mr. McGovern, just before we start with the official part of this meeting, our colleague Tom Massey lost his wife right before we went to break, and that obviously it was a enormously sad occurrence, and obviously we wish Thomas and his family our best, and want them to know that they're in our prayers, and certainly give him the time that he needs to recover. So I don't expect him here this week. Additionally, we've got a bad storm down in Texas right now. I don't think it'll make it all the way up to Massachusetts, but it will probably make it all the way to Illinois. And there'll be a lot of people in the path of this storm, and want members in those areas that are affected to know that we're thinking of them and their constituents. Seeing Mr. Morelli in the audience, I'm reminded that there's a storm in the White House, and that it is affecting many of us here locally in ways that we probably can't even anticipate now. But here's the problem. More than 600 days ago, the American people entrusted House Republicans with the gavels in the committees. It's easy to see why. After nearly 2 years of an unchecked Biden administration, the country was reeling. On their watch, the nation endured grim milestone after grim milestone. The highest gas prices ever recorded, the worst inflation in 4 decades, 12 major cities with new homicide records, an unmatched illegal immigration crisis. At every turn, radical Democratic policies either created the issue or actively impeded the solution, or both. Everyday Americans drafted House Republicans to protect them from these harmful policies and provide a check on the White House. This is a duty the majority takes very seriously. Indeed, that's why we're meeting today. Sometimes it seems that President Biden can't even put a sentence together, but the administrative state we're assured that he oversees continues to churn out reckless left-wing policies. What's more, his presidency still emboldens his enablers. Together, their agenda imperils everything from the sanctity of the vote and Title IX to the availability of effective and affordable home appliances. In keeping with what we were hired to do, House Republicans are advancing measures meant to protect our country from the rash and untimely destructive policies of the left. President Biden welcomed an invasion at the southern border. From his rhetoric to the over 60 destabilizing executive actions he has taken since he took office, every corner of the world took him up on the opportunity to enter our nation illegally. The numbers don't lie. Since the president entered office, there have been more than 9 million illegal immigrant encounters nationwide. That doesn't include the almost 2 million known gotaways who evaded apprehension on President Biden's watch, more than the previous decade combined. For context, May marked the 39th straight month where monthly illegal encounters were higher than even the highest single month in the Trump administration. To add insult to injury, President Biden released nearly 5 million illegals into the country and is openly talking about a plan to reward their fellow lawbreakers with amnesty. His choices are shameful, but not surprising. What is surprising is how fervently his surrogates and supporters dismiss concerns over illegal immigrants circumventing the letter of the law and corrupting our democratic process. The president and his enablers have been asking Americans to reject the evidence before their very eyes a lot. And this one is no different. And the evidence that non-citizens register to vote and illegally cast ballots in federal elections is substantial. The National Voting Rights Act, enacted in 1993, requires states to provide a federal voter registration form at the time an individual applies for a driver's license or for state benefits. In some states, non-citizens, including illegal immigrants, are eligible to receive their driver's license and public assistance, meaning non-citizens have undoubtedly been provided voter registration forms in these states, and they've been registering. For example, Pennsylvania admitted just a few years ago that it had inadvertently allowed over 10,000 non-citizens to register to vote, and a Georgia audit found that more than 1,600 non-citizens had attempted to register. Alarmingly, this doesn't stop at registrations. In 2011, Fairfax County, Virginia, discovered over 278 non-citizens on the voter roll and learned that 117 of them had actually illegally voted in Virginia elections. Additionally, over the past decade, several different Arizona counties reported finding hundreds of non-citizens on the voter rolls and determined that some of them illegally voted in federal elections. The SAVE Act, introduced by our colleague on the Rules Committee, Chip Roy, closes the loophole that created by the National Voting Rights Act and supercharged by the left-wing sanctuary policies. It requires a proof of U.S. citizenship to register an individual to vote in elections for federal office. Anyone who believes in safeguarding our democratic processes from illegal foreign influences should vote in favor of H.R. 8281. This administration's radicalism also threatens Title IX, which has protected women and girls' access to educational opportunities for more than 51 years. In April, the White House released an unlawful Title IX rule that, 1, ignores a Supreme Court ruling, and 2, strips students and educators of their rights, and finally enshrines in the law the left's ongoing war against parents. Since Title IX's enactment, female participation in high school sports has grown more than 1,000%, and collegiate sports more than 600%. Their radical actions threaten this progress. Unlike the White House, House Republicans believe that women should be safe in intimate spaces and men should not compete in women's sports. It's why we're advancing H.J. Res. 165, which prevents the administration's radical gender ideology from infiltrating education and hijacking Title IX. Thanks to the Biden administration, the left's radical whims are also poised to infiltrate everyday American homes. The Department of Energy's new dishwasher efficiency standards would take more than 12 years for the proposed efficiency upgrades to break even and would save Americans just $1.12 per year. Consumers understand what options work best for their households, and Washington shouldn't stand in the way of their appliance. Finally, the committee will consider H.R. 8772, the fiscal year 25 legislative branch appropriations bill. I anticipate my friend, the ranking member, will strongly disagree with my contextualization of today's meeting. I hope he will at least echo his fellow Democrats in the committee report and take no issue with the funding levels within the measure. The legislative branch subcommittee delivered a robust $5.5 billion package that supports Congress and our ability to work on behalf of the American people. With that, I look forward to the testimony from our panels, and I welcome the opportunity to move important legislation to the House floor. And I would now ask our ranking member, Mr. McGovern, for any remarks that he wishes to make.
Well, thank you, Mr. Chairman. And before we begin, I too want to extend my sincerest condolences to our colleague, Mr. Massey, on the passing of his beloved wife, Rhonda. We are so sorry for his loss, and we're thinking of him and his family during this difficult time. It's a terrible tragedy, and anyway, he'll be in our thoughts and prayers as well as his family. And I too, will keep in my prayers as well the members and their constituencies who are dealing with these terrible storms that have now hit our country, and hope that they get through all of this get through it safely. And now on to the legislation that we're going to be considering here today. You're absolutely right. I disagree with everything you said, and even more strongly than I usually do. This committee should be a place where we debate big ideas, where we tackle important challenges and make real progress. But under the Republican majority, we've done the exact opposite. And this week's measures are no different. We have another funding bill that goes after the LGBTQ community, attacks dreamers, and will make Congress less reflective of the people we represent. We have another thinly veiled attempt at voter suppression under the guise of preventing voter fraud. Even though we all know the voter fraud that my Republican friends are talking about is just shorthand for the big lie that Trump pushed when he tried to illegally steal the election after he lost it fair and square. We all know what's going on here. Republicans do better in elections when fewer people vote, so they want to make it harder for people to actually be able to vote. Look at who this bill would disproportionately impact. People who change their name when they get married, including millions of women. People who can't afford to take a day off from work to go down to the town clerk and get a copy of their birth certificate. People who don't have $130 to get a passport. This isn't about making our elections more secure. It's about making it harder to vote. That is what this bill is aimed at doing. Now, we know what's going on here. Republicans are laying the groundwork for them to discredit the upcoming election. If they win, you'll never hear about this until the next election. But if they lose, they will say it is because of voter fraud. Voter fraud, which, by the way, the Heritage Foundation, you know, that right-wing think tank that you guys always associate yourself with, they can only find 24 cases of it in the last 20 years. They say this is about protecting the right of citizens to vote. For every case of real voter fraud, they want to take away the votes of millions of actual citizens. What a disgrace. We have another effort to make it easier to discriminate on campus, turning back the clock on civil rights because House Republicans continue to prioritize radical culture wars. And just days after July 4th, a day we celebrate actual freedom from tyranny, Republicans have brought up bills about freedom for refrigerators and dishwashers. I mean, you really can't make this stuff up. They have no problem taking away the rights of living, breathing human beings, no problem depriving women of their reproductive rights, stripping away freedom from the LGBTQ community, hindering families who want IVF. None of those groups deserve freedom, according to the Republicans. But refrigerators, sign them up. Apparently, nothing says freedom to them quite like forcing their constituents to pay more on their electric bills. For the record, if somebody wants to keep a 50-year-old refrigerator, that's their right. Nobody's going to stop them. That's nuts. And it's not what this bill is about. This is about Republicans giving billion-dollar companies the freedom to cut corners when they make appliances, keeping all of our utility bills high and polluting the air and water while they're at it. I mean, that's what they are in favor of. But, Mr. Chairman, at the end of the day, it's not just about the legislation here. It's about two competing visions for America. Democrats want an economy that lifts people up. We're fighting for workers. We want opportunity for kids, success for families, and dignity for seniors. We want democracy to be secure at home and around the world. We have a vision of a better future and an idea of how to get there. And these bills before our committee today once again show that Republicans are more interested in division and taking us backwards and turning the clock back. On reproductive freedom, on voting rights, on lowering prices, on holding big corporations accountable, on all these things and more, they want to drag us back. That's what their party now stands for, and that's why we're wasting time with more misguided MAGA junk instead of working together to get things done for the American people. And with that, Mr. Chairman, I yield back.
The Chair thanks the gentleman for his comments. Without objection, any prepared statements that our witnesses may have will be included in the record. I do want to call up our first panel, Chairman Brian Steele and Ranking Member Joe Morelli from the Committee on House Administration. And Chairman Steele, I welcome your testimony.
Chairman Burgess, Ranking Member McGovern, members of the committee, thank you for inviting me to testify in support of H.R. 8281, the Safeguard American Voter Eligibility Act, known as the SAVE Act. I'd like to thank my colleague, Congressman Chip Roy, for his sponsorship of this bill and his collaboration in working to get this legislation in final form. I'd also like to thank Speaker Johnson, his team, and our committee staff for all the time and resources dedicating to bringing this bill to life. As chairman of the Committee on House Administration, I've been diligently focused on elections. Our committee's introduced over 50 pieces of legislation and marked up 15 elections bills. We've held 12 hearings, heard from 60 witnesses, and even held a field hearing in Georgia to hear from Americans directly on what is going right and what their concerns are about our election system. We've raised awareness on private election funding, commonly known as Zuckerbucks, and its potential to influence our elections administration. We've passed legislation to close a loophole that allows foreign nationals to spend hundreds of millions of dollars to influence American elections. As a House, we passed legislation to prevent non-citizens from voting in Washington, D.C.'s local elections. This bill, the SAVE Act, is one of many we hope to bring to the floor. In the past few decades, Americans' faith in the integrity of our elections has eroded, and it's Congress's responsibility to help restore confidence in our election system. The SAVE Act would do just that. Through the SAVE Act, we'll strengthen our elections administration and keep American elections for American citizens. In recent years, we've seen a growing number of jurisdictions across the country allow non-citizens to vote in municipal elections, including right here in our nation's capital. In Washington, D.C., a non-citizen only has to reside in the district for 30 days in order to vote. Imagine if that policy was applied across the country. The SAVE Act contains critical reforms to existing legislation and strengthens current law by requiring documentary proof of U.S. citizenship to register to vote in federal elections. The National Voter Registration Act currently requires states to give voter registration forms to everyone who receives a driver's license, regardless of citizenship. For example, in Illinois, like many states, non-citizens can obtain a driver's license. Under the NVRA, these non-citizens would be given voter registration forms. And just a few years ago, Illinois had to remove hundreds of non-citizens from its voter rolls. All an applicant has to do is check a box saying they're a citizen, and the citizenship verification process is over. Following the 2013 Supreme Court case, Arizona versus Intertribal, the NVRA prevents states from asking applicants for confirmation of citizenship. The SAVE Act would require states to obtain documentary proof of U.S. citizenship and identity in person when registering an individual to vote in a federal election. The change to the NVRA would direct states to establish a process for applicants who do not have documentary proof of citizenship, but are in fact U.S. citizens, under a process developed by the Election Assistance Commission. The SAVE Act would require states to set up a program to remove non-citizens from their voter rolls. In order to assist with this process, the bill would give states immediate and free access to federal and state databases with citizenship information. In a recent committee hearing, we heard evidence of non-citizens appearing on voter rolls in states across the country, and it's critical that we provide the resources states need to remove non-citizens from their voter rolls. By allowing this access, states can streamline registration processes and ensure that non-citizens are not registered to vote. Lastly, the SAVE Act will direct the Election Assistance Commission to update any guidance associated with the bill. The SAVE Act will also ensure that states with same-day registration can comply with the bill. American elections are for American citizens, and it's our duty to make sure it stays that way. Through our work on the Committee on House Administration, Republicans have worked tirelessly to protect American elections. President Biden issued an executive order directing federal agencies to use taxpayer money to register people to vote. By passing the SAVE Act, we can make sure that only eligible Americans are by passing the SAVE Act, we can make sure that only eligible American citizens are registered to vote. As we approach the 2024 election, election integrity is more important than ever. We must ensure Americans have confidence in our election system and that their vote will count according to the law. We must get the SAVE Act to the floor of the House of Representatives to vote to protect our elections. Thank you, Mr. Chairman, and I yield back.
Thank you, Chairman Stile. Mr. Morelli, Ranking Member Morelli, you are recognized.
Thank you, Chairman Burgess.
And can I just say, it's good to have you back here in the Rules Committee. We spent a lot of hours up here together in years past. So welcome back.
Thank you.
We kept your place for you.
Thank you, Mr. Chairman, and Ranking Member McGovern, and thank you to all the members of the committee. And I do want to express as well my sympathies to the Massey family for this tragedy, and our prayers are certainly with them. Thanks for allowing me time. It is great to be back here. I had the great privilege of serving for 4 years on the Rules Committee. I think I sat where Mr. Norman, my good friend from the fifth floor of Cannon, serves and sits, and enjoyed immensely the 4 years I was here. I wish today I was here under different circumstances. I am grateful for the work you do, and thank you for having me, but I must strongly object to the bill before us this afternoon. Every American should be absolutely clear about why Speaker Johnson and House Republicans are advancing this bill. For all the hysterical rhetoric surrounding the SAVE Act, Republicans have one real purpose here: to continue to erode the confidence of Americans in our election systems, to destroy, in fact, our faith in our democracy itself. And I cannot imagine a more disgraceful exercise. As members of Congress, we are obligated, we are duty-bound, we swore oaths to defend the republic, not disfigure it. This bill is a vehicle for lies, plain and simple. The sole objective is to convince Americans, to scare them into believing that non-citizens, without a shred of evidence, are going to steal the election from Donald Trump. But Americans are not as naive as many of my colleagues think they are. Republicans know, they know that non-citizen registration and voting in federal elections is already illegal. To register is illegal. To vote is illegal. It leads to deportation. They know this simply does not happen. The Committee on House Administration has held several hearings on non-citizen voting, and my colleagues could not produce any evidence to back up their claims. In fact, Speaker Johnson admitted he had absolutely no proof of non-citizen voting in federal elections. But this is not a new project. As the ranking member has articulated, in 2020, Donald Trump and his allies, many of them in Congress, tried to deceive Americans about the security of our elections. They claimed that absentee ballots would lead to voter fraud. They claimed that extended early voting would lead to voter fraud. None of these claims ended up being true. Everyone in this room knows those claims were false, even if they will not admit as much. The Stop the Steal claims were lies, as history has shown, but led to one of the most shameful days in American history. The deadly, violent attack on this building on January 6, 2021 should never have happened. Should never, of course, be repeated. But as the ranking member has stated, the SAVE Act is a purposeful way to lay the groundwork to begin the conspiracy for another insurrection. The former president and his allies thought Americans were gullible enough to believe the lies of 2020. They hope Americans are gullible enough to believe those lies today. Americans, however, are smarter than you think. This bill will not solve any problems American elections do face, from chronic underfunding to constant violent threats against election administrators. What will the SAVE Act do? It will, quite simply, disenfranchise millions of eligible American citizens. It will greatly increase the burden, increase the cost in both time and money for any American citizen that wants their voice to be heard. The bill would especially burden military voters, tribal voters, rural voters, survivors of natural disasters, many of which we're experiencing throughout the country today, and the tens of millions of married women in America who have changed their names. The fact that by advancing the SAVE Act, Republicans will make it harder for men and women in uniform to register to vote shows how misguided this legislation is. Republicans are clearly telling the American people they believe that no barrier is too high to place in the way of the ballot, no burden too heavy for Americans to bear if they wish to vote. The SAVE Act is the most extreme, most radical election bill in living memory. It will quite literally disenfranchise millions of Americans. Republicans doing this all damage just to help Donald Trump undermine American faith in our democracy. As I said before, the American people are not as naive as Speaker Johnson and House Republicans think they are. They proved that in 2020, and they will prove it again this November. The tragedy here is that the Republican backers of this bill have such a poor view of their constituents, they're willing to lie to them in ways that they have already done irreparable damage to our nation, in ways that will continue to do untold damage to our nation's core identity, our elections, our democracy. I wish House Republicans had the courage to stand up and say enough is enough. I wish they had the courage to openly debate this damaging bill. Instead, the majority wants to move this legislation under a closed rule, blocking any amendments that could improve this fatally flawed SAVE Act. Sadly, I fear they don't. With that, Mr. Speaker, or Mr. Chairman, I yield back.
I thank both of our witnesses for your testimony. Chairman Stile, let me just ask you, in 2004, Congress passed the Secure ID Act. It was one of the 9/11 recommendations. In fact, congressional Democrats at the time were really anxious that the 9/11 recommendations be adopted into law. And the consequence of one of the 9/11 recommendations was that there be citizenship verification on state-issued IDs. So I know, the reason I'm asking is because I thought in your testimony you said there was not a requirement, but in Texas, I was required to show a birth certificate or passport when I renewed a driver's license prior to a couple of years ago. And I thought that was because of the Secure ID Act that Congress had passed, and that all states now had come into conformity with the legislation passed by Congress in 2004, which again was a bipartisan piece of legislation. So is that now a requirement?
You do not need to be a U.S. citizen to get a real ID. Real ID can be used as a mechanism to show citizenship status if the state indicates that on the real ID, but you do not need to be a U.S. citizen to obtain a real ID.
So that does not,
In and of itself, it does not. It could be modified in a manner that would allow that, where you could identify a citizen on a real ID. A state could take that action. That would be a great step forward to enhance the integrity of our election.
is that something that you've looked at your committee?
We've not delved into it in great detail, other than in the broader package of election proposals that we've put forward. We have explored that as a mechanism that would be, I think, incredibly helpful in the U.S. election system.
Well, let me just ask you, can you address what Mr. Morelli said, that there's been no evidences? You've had the hearings in your committee. You looked at the evidence. Is there evidence that this, in fact, is necessary, the SAVE Act that we're bringing forward?
We've held a number of hearings, listened from a number of experts, and there is consistent evidence of non-citizens voting in U.S. elections, which is why this legislation is essential. We could look at a House race in 1996, a contested House race where, under further review, 624 non-citizens voted in a House race in California. And as we know, one of our colleagues is here who won by 6 votes in the state of Iowa. And so every single individual who's a non-citizen who votes illegally cancels out the vote of a U.S. citizen, and often we know House races are narrowly decided. And when we look back at the empirical evidence, and you see in 1996, over 600 non-citizens did vote. We can look at Fairfax County, Virginia, not far from where we sit here in our nation's capital. In 2011, we know over 117 individuals voted. We know that individuals are on the voter rolls in states like Ohio, where their Secretary of State recently removed those individuals. So we continually see this challenge prop up, which is exactly why this legislation is essential to pass.
Well, I thank you for your work on this. I thank you for your time and attention today. I'll yield to Mr. McGovern for any questions he might wish to ask.
Yeah, no, I have a few. Chairman Stiles, we received a letter from you requesting a closed rule, and then we received a letter from Ranking Member Morelli asking not even for an open rule, but for a structured rule. Why are you asking for a closed rule? I mean, do you really think that this bill can't be improved in any way, shape, or form, especially since some of us believe that this bill could disenfranchise millions and millions of people? What's the rationale behind shutting off all amendments for Democrats or Republicans?
We had an amendment process as we went through regular order at the committee level.
You're one committee. I mean, not just the people on your committee care about voting rights. People on the Rules Committee care about voting rights. Judiciary Committee cares about voting rights. I would even say that people on the Transportation Committee care about voting rights. This is a big deal. And some of us believe that this bill will literally disenfranchise millions and millions of people. So I guess what is the justification for not allowing any amendments? Mr. Morelli has an amendment. He's the ranking member on your committee. Why should he be denied the right to offer and debate an amendment on the House floor?
Well, in fact, Mr. Morelli did offer amendments, and we debated those in committee, as I previously noted.
Yeah, so you had 12, how many members on your committee?
There's 12 in
There's
committee
12
on House
members on your
Administration.
committee. There's 435 members of the House. I mean, you don't think we should be able to debate these things, on something that impacts every single district in this country? I'm just stunned that my Republican friends who promised they wanted a more open process continue to insist on shutting down the process and closing things up so that no amendments can be offered. But I ask unanimous consent to put in the record the letters from both Chairman Stile and from Ranking Member Morelli on the request for a rule. I just find it stunning that on an issue, on a topic like this, that really not just 12 members have concerns about, that you are saying that we should shut the process down, which I'm sure that this committee will do, because that's what this committee normally does. Mr. Morelli, Chairman Stiles talked about the massive voter fraud. Do you want to comment on that?
Yeah, I mean, I think, look, we have 350 million Americans. The odds that one or two non-citizen could ultimately vote, I suppose, is possible. But what's being posited to the American people, and what Speaker Johnson even talked about without having any evidence. Suggestion is that there's massive efforts to get non-U.S. citizens to vote in federal elections. I'll repeat what I said earlier, which is it's illegal to register to vote in the United States if you're not a U.S. citizen. It's a further penalty if you actually voted in a federal election and weren't a U.S. citizen, which leads to deportation. So for all the suggestion that people are doing this in droves and risking both violations of law and deportation, crazy. There's no evidence that this is done, and certainly not any evidence done in a systematic way. So to make the extreme, and I mean extreme changes to election law, which federalizes it, by the way, my colleagues on the committee, particularly Republican colleagues, are always talking about how these are state elections, and the federal government should not involve itself in state elections. But here we are building a massive set of documentary requirements for people simply to register to vote. It is beyond, certainly, given what is suggested is the problem. This is not even a solution in search of a problem. There's no problem, but this is a bad solution. And this would even go so far to potentially subject a poll worker to imprisonment and violating the law and imprisonment, even if they registered a voter who's a U.S. citizen. But if they didn't get all the documentary proof appropriately, they could face fines. I mean, we're already struggling to find people to work in elections, fearful of intimidation, fearful of threats against their life and their families. This will have a chilling effect. It simply is not a problem. And frankly, the couple of cases that were cited before the committee involved a government, state of Pennsylvania, state of Colorado, who made mistakes which they acknowledged, which they immediately went to enormous lengths to clarify, and there's no evidence that non-U.S. citizens are voting in federal elections.
Chairman Stile, are you familiar with Project 2025?
Only at a high level.
I mean, I'd urge you to read up on it a little bit more because it's horrifying. You should take a closer look at what some of your fellow Republicans have been up to. It's a plan to essentially install Trump as a dictator, which is what he said he wants. It's a roadmap to end American democracy, to ban abortion, to dismantle constitutional checks and balances, consolidate power into the Oval Office, and use the presidency for revenge against Trump's personal enemies. And when I say this would end our democracy, I'm not exaggerating. Project 2025 advocates for a terrifying expansion of federal power over the lives of everyday Americans. And it's deeply disturbing, and I encourage every American to look into it. Chairman Stile, do you know who Hans von Spakovsky is?
Yes, he's testified before my committee.
Yeah, because on May 16th, 2024, you and your Republican colleagues on the committee held a hearing on the SAVE Act, echoing election conspiracy theories and praising this bill. And one of the witnesses you called was Hans von Spakovsky, who's the author of Project 2025. When you invited him to testify on behalf of this bill, were you aware that he was one of the leading authors of Project 2025?
I'm familiar with his expertise in federal election law.
Yeah, so on May 23rd, 2024, a dark money think tank associated with the Heritage Foundation issued a public statement in support of the SAVE Act. And the Heritage Foundation is the organization behind the extremist proposals in Project 2025, and they are also publicly supporting the SAVE Act. Do you disavow their support, given what we know about Project 2025? I've explained to you what it does. Is that enough for you to distance yourself from their support of this bill?
Hans von Spakovsky is an absolute national expert in federal election law, was one of many witnesses who testified before us and walked us through, as many of our witnesses did, the challenges that we've seen of non-citizens voting in U.S. elections. It's the reason that this legislation is essential to make sure that we're protecting U.S. elections for U.S. citizens.
Yeah, and I get it. I mean, you've said over and over you think he's a credible. Obviously you believe the Heritage Foundation is a credible organization, and you believe he's a credible witness. But again, he is one of the major authors of the Project 2025. And you invited Mr. Spakovsky to testify in front of your committee, I think on 3 separate occasions. Is that correct?
It could be up to 3, yeah. He is a national expert on federal election law.
For the record, my staff actually looked into it, he did testify 3 times. But when I look at this bill, and I look at some of the stuff in Project 2025, there's a lot of crossover here between this bill and Project 2025. And I think, it's one of the fears that we have is that, that this is, again, advancing this very radical idea, and that you would invite the author of Project 2025, one of the architects of this initiative, to basically be, one of your expert witnesses is a little bit disturbing. Let me ask you one final question. Do you think that the president has the authority to mobilize the National Guard to seize ballot boxes in Democratic states?
I'm not familiar with what you're discussing.
Well, I mean, well, let me say, in the last administration, prepared an executive order to do just that. Stephen Miller, who spoke at your press conference when you announced this bill, and who is reportedly also involved in Project 2025, has now apparently said, according to reporting, that he thinks a future Trump administration should nationalize the Guard for deployment in Democratic states. And as I said in my opening statement, this bill is all about sowing distrust and trying to undermine faith in our elections so that your side can continue to use non-existent voter fraud as an excuse to seize power if and when you lose. This is really serious and dangerous stuff. And I would urge you to actually read the Project 2025 proposal. It's something that hasn't been talked very much about. There's some reporting on it. I want to insert unanimous consent to insert 2 articles talking about the connection between Project 2025 and Donald Trump's candidacy. I hope I could.
Without objection.
I got to tell you, I find all this very, very chilling. And again, as I said in my opening statement, I think this is all about you guys fearful that you will lose the next election and trying to find an excuse to, like happened in the last election, to say that it wasn't a free and fair election, that it was a fraudulent election. Every single court in this country said it was a free and fair election. I mean, let me ask you one final question. Do you believe that Donald Trump lost the last election?
I'm pretty sure we're all aware President Biden's the President of the United States.
Well, that's not the answer to the question. The answer is whether you think Donald Trump lost. And the fact that it is so difficult for my Republican friends to even admit that he lost because you're afraid you'll offend him or some of his more extreme supporters, and that you bring people like one of the architects of Project 2025 to come and testify in favor of your bill, to have Stephen Miller at a press conference. Boy, this stuff is not good. I thank you for indulging me. I yield back.
Thank you, Mr. McGovern. And I just wanted to they handed me a few facts about the amendment issue. And I do understand, Mr. Morelli, that there was one amendment submitted for this bill, and it was your amendment, and it was 219 pages long, and you submitted it less than 2 hours before the hearing, is my understanding.
Would the gentleman yield for?
Mr. McGovern.
Let's just set the record straight. There was no call for amendments. The Rules Committee usually puts out a call and asks people for amendments. They did not receive, no notice went out asking for amendments. And by the way, Mr. Morelli's amendment is actually germane. And he's a former Rules Committee member, too.
And Mr. McGovern, I had to make sure that I was clear on it. And there have been structured rules that have been done before without a call for amendments, and they are still allowed to submit amendments. Members are still allowed to
So can we do it now? He has an amendment. If we can make this germane amendment in order, great. This shouldn't be controversial.
And Mr. McGovern, they're saying there was no opportunity to vet. I think that was part of the point, where it is a 219-page amendment. submitted less than 2 hours before, and there was no opportunity to vet and look through the amendment and understand what was in it.
We were just told it was offered in committee, so this is not a new concept. So, I don't, I appreciate the gentlelady's indulgence. I think we just got to call it out for what's happening here. This is about basically making sure that no amendments can be offered, that there could be no debate. This is about shutting down the process.
Mr. McGovern,
Yes.
I'm going to recall my time because, reclaim my time because, no, that's not what it is about. It is about the opportunity for staff to be able to understand an amendment that is 218 pages long. And I understand you're going to say it was
And the committee of
admitted, it was
jurisdiction
put in.
would be the one that would vet it, and they had a chance to look at it.
I'm
So,
reclaiming my time.
You don't have to vote for it. I'm just saying, can we make it in order?
Mr. Chair, or Mr. McGovern, it is just 2 hours beforehand that this was submitted. And I understand you're going to say that it was submitted in committee, but then it should have been submitted earlier than that or anything to make sure that this, so we're not,
I don't-
we are not shutting things down. This is one
This is-
amendment.
We're shutting
It
this
was
process
one
down.
amendment
This-
down.
Yeah, on a voting rights bill. We don't know
I
what
reclaim my
amendments we would have
time, Mr.
gotten if we
McGovern.
had-
I reclaim my
if
time.
we put out a call for amendments.
Mr. McGovern. Well, and just my understanding is that, like I said, there was the one amendment, but I do have a couple of questions for for the chairman, Mr. Stile. Mr. Morelli had mentioned, I think it was that we were, there was claims about not having a military, I think it was military, a woman who needs to change her name or anyone who changes their names in natural disasters, that we are somehow impeding them from voting. And I was wondering if maybe you could dispel some of those claims.
So anyone, regardless of sex, gender, color, creed, can obtain a driver's license. Anyone, regardless of sex, can obtain a birth certificate. Anyone, regardless of sex, could obtain a social security card or other documentary proof of citizenship. So if an individual goes through to change their name, they would get an updated state-issued ID. They may update their social security card. So the process in this instance, as it relates to documentary proof for voting, would mirror those changes.
So that in no way impedes their, like the claims were made, that would impede their ability to vote?
It would not, in the context that it's the same process that we would go through for other actions when an individual would change their name.
Thank you very much. And in my state, Minnesota is one of the states that allows illegal immigrants to obtain driver's licenses and other state IDs. And can you talk about more about why states like Minnesota are increasingly difficult to root out non-citizen voting when they're allowing non-citizens to get those IDs that are necessary for voting?
Well, obviously, I'm not only so nuanced on the state of Minnesota's election laws, but states obviously that have photo ID. Photo ID in particular, an individual that has a driver's license where the state gives driver's licenses to illegal immigrants would not be able to utilize that as a mechanism to determine citizenship. And again, under HAVA, the congressionally passed law, states aren't allowed to require proof of citizenship. And that comes from a Supreme Court case, Arizona versus Intertribal, that says the HAVA law preempts state law and prevents states from checking proof of citizenship. It's why this legislation is so essential to not only allow states to confirm citizenship of a voter, but to require states to obtain proof of citizenship from a voter. And so as the United States has countless individuals who are here both legally and illegally as non-citizens, has grown dramatically. This is an opportunity for us to make sure that we're protecting the integrity of U.S. elections for U.S. citizens.
Thank you, Mr. Chairman. And
I'm sorry, may I
Mr.
just
Morelli?
respond on the military? So if you're in the United States military and you try to register, your military ID will no longer be sufficient. You'll have to bring your military record with you, which shows your place of birth. But if your place of birth was outside the United States, you could still be a U.S. citizen. You could have either been born abroad to U.S. citizens, or if you were born in Germany and came to the United States as a child and became a U.S. citizen and served in the military, now you'd have to show your military ID, your military service record, which doesn't show you having been born in the United States. Now you got to get additional information that demonstrates you're a U.S. citizen. This is for someone who's serving in the military, who's a U.S. citizen, to have to go through 3 or 4 documentary pieces of evidence just to register to vote in the United States? Is that what we want in this country? Is that the kind of barriers we're going to put in front of people? And frankly, you'd have to go to a council, get a counselor report of birth abroad if that was the case. It's just expensive. It's those kind of barriers. Right now, you go with your driver's license or your military ID. It ought to be sufficient to register to vote, particularly when you're asserting that you are indeed a U.S. citizen. That's required.
Chairman Stile, you want to respond?
I think it's important to note that while that would be one mechanism of showing your documentary proof of citizenship, showing a U.S. military ID together with U.S. military service record, showing the applicant's place of birth, that would be one option an individual could utilize to demonstrate documentary proof of citizenship. Obviously, a valid U.S. passport, a real ID with citizenship indicated on it. But also in this legislation, we set forward a path for the Elections Assistance Commission to set up a structure to allow additional mechanisms to provide proof of citizenship. And so what I mean by that is making sure that we're providing access to U.S. databases that can confirm citizenship of an individual, providing that at no cost in a near real-time opportunity.
Thank you. And I just want to say thank you for bringing the bill forward, and Mr. Roy, thank you very much, because I hear it more often than not that constituents are asking for election integrity, and I appreciate that you brought this forward. And I know that there's a lot of conspiracy theories that are being discussed from the other side, but I think that we need to be looking at election integrity, and I appreciate you bringing it forward. And with that, I would call on, I believe, Mrs. Scanlon from Pennsylvania.
Thank you, Madam Chair. Okay, so we have a bill here which is pretending to protect our election systems from people who are not citizens voting in our federal elections. But let's be clear that that's not happening. It's already illegal for non-citizens to vote in federal elections, and there is no evidence that non-citizens are voting in federal elections. No study backs this up. Including, in fact, to the contrary, the Cato Institute has put out a study that found that non-citizens don't vote illegally in detectable numbers. Sure, things happen everywhere, but this is not a real issue. Voter fraud is incredibly rare, and non-citizen voting is even more rare. So all this bill is going to do is disenfranchise American citizens. This bill repeats the GOP playbook for modern-day voter suppression, which we've already seen and rejected in my home state or Commonwealth of Pennsylvania and numerous other states. So by that I mean when you implement strict voter ID requirements which discriminate against eligible voters by limiting the forms of ID which the law will recognize for voting purposes. The classic example is the state that allows voters to vote if they have a hunting ID but not a student ID. So we don't need to look too far for examples of restrictive ID. One of the primary forms of ID allowed by this bill is real ID, which, as Chairman Stile noted, it does not, in fact, say that it shows citizenship, and in fact, non-citizens can get real ID in a number of different situations, and not all states indicate citizenship. So we're imposing yet another burden upon our states if they're going to have to go back and add citizenship to their real ID issuance. But beyond that, again, something we're very familiar with in Pennsylvania is that people have not gotten real ID. It's estimated that only 20% of eligible Pennsylvanians will have real ID by the time it becomes mandatory in a year. Other states are similar. Kentucky, I think, is only around 30%, because many states had large conservative factions who were afraid of real ID, who did not want it to be mandatory because they did not want there to be a national ID system. They did not want big government issuing national ID. So there's been very slow uptick, and it's kind of, I think as Mr. Morelli noted, it's a little bit odd that we have the House Republicans pushing additional requirements here upon our states and upon people who are resistant to Big Brother knowing everything about them. We saw the privacy concerns, the low acceptance rate of real ID, and it's been around since 2005, and we still have less than half the people who could get it using it, shows that if you put an administrative burden on citizens to prove their citizenship in order to register to vote, if you don't make it easy for them to do that, you're going to reduce the number of registered voters, which is something that we had to address when we had strict voter ID rules in Pennsylvania, and we proved that 600,000 eligible voters in Pennsylvania were going to be disenfranchised because the forms of ID, which had been accepted by the Republican legislature under that legislation, were too restrictive, and we see a similar thing happening here. If this bill passes and it's implemented nationwide, Republicans will have taken away the vote from millions of eligible American voters. Not to mention that it's going to place a significant financial and administrative burden on our state governments, which are already struggling to keep up with the requirements for Real ID and other forms here. Do our Republican colleagues know this? Did they not do their homework when drafting this bill, or was the purpose of the bill not really to address this non-existent problem, but just to give an opportunity to talk about voter fraud that doesn't exist? So it's pushing lies about our elections. It's really problematic, and I just obviously can't support this bill because it goes contrary to all of the evidence and a lot of work that I've seen and participated in over the years. Ranking Member Morelli, Mr. Style mentioned that Real ID in and of itself doesn't indicate citizenship, and that not all states have such a marker. Has there been any testimony or any evidence before the committee, which brings this bill to us, about how many states do indicate citizenship?
No, there's no requirement that Real ID have citizenship on it. So even though it's cited as documentary evidence, it's only for those states who would require citizenship on Real ID. But Real ID does not, as the chairman indicated, does not have that requirement. I mean, here's the challenge, is it's going to take an armful of documentary evidence and a lot of work now to register to vote. The barriers for married women who have a different name than is on their birth certificate. And even if they showed a birth certificate, their driver's license, they're going to have two different names. One is the name that they were given at birth. One is if they've changed their name, those aren't going to agree. You're going to have to provide documentary. I mean, think about this, the steps that you'll need to take simply to register, which is your right as a U.S. citizen to vote in elections. But now you're going to have to go through more information than you'd have to do almost any other activity, and this is guaranteed by law. It really is shocking the amount of evidence will be necessary. And by the way, if you went to register to vote and you had a birth certificate and your married name, or I'm sorry, a driver's license, your married name, and a birth certificate with a different name, and the poll worker knew you because they're in the same neighborhood, and so I'm going to let this person register to vote, they did that, they'd be guilty of a federal crime. They could face jail time. And by the way, it doesn't mean that you weren't a U.S. citizen. It just means they didn't compile the proper documentary evidence because they knew who you were. Is that what we want now for poll workers who know you, who know you're a citizen, who live down the street from you to be facing jail time because they didn't get the documentary evidence that they thought was, that the bill requires as evidence that you're a U.S. citizen? Boy, that's shocking to me.
Well, it's shocking and it's chilling of probably one of our most fundamental American rights, to have a say in who runs the country, who we get to vote for. So thank you for your testimony. I would yield back.
Thank you very much. I would yield to Mr. Norman of South Carolina.
Thank you. Joe, good to see you here.
Nice to see you, Mr.
Thank you all
Norman.
for coming. I keep saying there's no proof that, illegals are being not only registered, but they're doing it illegally because they're illegal. Is it not true that Pennsylvania admitted a few years ago 10,000 non-citizens were registered to vote? Is it not true that Texas had a similar problem where nearly 100,000 non-citizens were allowed to vote? Is it not true that Illinois implemented automatic voter registration several years ago and hundreds of non-citizens ended up on the rolls? Is it not true that Ohio had upwards of 100, I think, in one precinct of non-citizens? It's not true that a Georgia audit found more than 1,600 non-citizens had attempted to register to vote. Virginia had nearly 1,500. You know, when you look at what's happening in this country with the illegals, Congressman Stiles, why is this a president allowing what we know of is 13 million plus in this country without any barriers? Why do you think, what goals does this administration have?
I have a lot of questions on a lot of actions.
Could it be registering to vote and including them in the census?
Could be.
What consequence, you know, at the voter, when you register to vote today at the bottom, you fill the questionnaire out. At the bottom, I am a U.S. citizen. You check that. What consequences are there if you fraudulently check the box and then you're not?
I mean, that is a federal penalty. But what we're noting is the states cannot require additional proof of citizenship. So if we look at HAVA, the federally passed Help America Vote Act, and then we analyze the 2013 decision, Arizona versus Intertribal, which says that federal preemption prevents states from actually requiring or looking further after that box has been checked. The concern is states don't have an ability today to confirm citizenship beyond the self-attestation that you just noted. And so this bill provides an ability for states to do that. Not only that, it requires it to make sure that U.S. elections are for U.S. citizens.
So this is just more of a verification that if you check that box, there's a way to have consequences for those who are doing it fraudulently.
Not only that, but it's actually a check that that box has been, that there's confirmation that you are a U.S. citizen rather than simply allowing an individual to check a box.
Well, what in South Carolina, we had noticed that there were 3 plane loads of illegals that came into Spartanburg County that were going in the Medicaid, the government offices, they're giving them a registration. Now, there's nothing wrong with that, but to verify that they are who they say they are, what we're doing is involving the Secretary of State, and we're doing this as we speak. There are 2 statutes that have never been used that we're citing in this. And we're going to the Homeland Security to get, and we've used the first, I think the last year of new registrants. And we're going to check and see, and it's been, like this administration has in so many cases, they just don't respond. When they don't respond here, then we're going to sue them to get the information and then keep ratcheting that down. Does this, is this a stepping stone toward the verification of when you check that box, you are a registered citizen of this country?
I'd go beyond a stepping stone. I'd say that this actually provides the proof that an individual who's registering to vote is a U.S. citizen by providing one of the documentary proof mechanisms that is in this bill.
And to have secure elections, we need to verify that. I may verify that I go the speed limit, but I've got consequences if I do not. There's no consequences on this, especially with 15 million illegals in this country to begin with. Mr. Morelli, do you have anything on that?
Yeah, first I'd say, as it relates to South Carolina, aside from the federal prohibition, South Carolina law already requires individuals to be a U.S. citizen to vote not only in federal but state and local elections. And the state has numerous systems, as I understand, in place to prevent non-citizens from registering and casting a ballot. And when registering to vote, every single voter must swear under oath in South Carolina that U.S. citizens are eligible to vote and that they are a U.S. citizen. Giving false information, as I understand it, can result in substantial prison time, not for federal charges, but because it violates South Carolina statute. In addition to facing prison time potentially, South Carolina State Election Commission also conducts active audits of voter lists to ensure that non-citizens are not on the rolls. So, and as I understand it as well, the South Carolina State Elections Commission has found no evidence, and they've indicated this publicly, that non-citizens are registered to vote in the state. So I think South Carolina not only has made it their business in federal, which is already against federal law, but also at the state law to do it. And as I understand it, and I defer to you as to whether or not you have faith in the South Carolina State Election Commission, but they have published reports after doing continuous audits, that there is no such, that is an activity that doesn't happen.
But we had them on the line last week. And by checking the box, that there's been no further gathering of information to make sure that that box is true, that what they say. That came from them last week. That's why it's so interesting. They're all in favor of what we're doing in South Carolina. Ms. Stiles, you have something?
Yeah, I think you're spot on, Congressman Norman, is that once that box is checked by an individual, federal law with the Supreme Court interpretation actually prevents further proof of citizenship or a requirement that the box that's checked is actually validated that that individual actually is a U.S. citizen. I think I was previously said HAVA, I should have said NVRA.
NVRA,
And so
right.
when NVRA is reviewed by the Supreme Court in 2013 in Arizona versus Intertribal, what they're saying is with federal preemption that states are not able to actually go through and verify the citizenship of an individual that checks the box. And so once that box is checked, the whole step is complete. This legislation is authored by Congressman Roy, says, no, what we're going to do is actually require proof of citizenship, provide that documentary proof that the individual that checks the box is actually a U.S. citizen to further enhance the integrity of our elections.
So it's just verifying that once you check that box, you are who you say you are.
Exactly.
And there's no, in South Carolina, there hadn't been any steps taken. They were unaware of this. Now, we're going through the Homeland Security to get the information. And Stephen Miller has done a lot of work on this. And this is the two laws that he has we're making, is what we'll be using to. But, you know, this Biden administration, if they really want to have honest and fair elections, let's verify it. Again, if I get caught speeding, I think I have a ticket. There's a way to verify that. It's called a meter, speed meter. But with voting and with this invasion that this president is allowing, it's criminal to not do this. And I hope other states will do the same thing. Look, thank you, Chip. Thank you for bringing this up, and look forward to supporting it. I yield back.
Thank you, Mr. Norman, and I would call on Mr. Roy from Texas.
I thank the chair. Appreciate the gentleman from appearing. Just a couple of questions. For the chairman, I think you just articulated some of the things I wanted to make sure was clear for the record about what we're talking about here. Under current law, but I want to make sure it's clear for everyone to understand. Under current law, if a state wants to ensure that it is only a citizen voting, does that state face barriers to ensuring that that is the case?
100%, that's an accurate statement. They're not allowed, they're actually prevented from asking applicants for documentary proof of U.S. citizenship under current law, and that's the Supreme Court's decision in 2013 of Arizona versus Intertribal, their review of NVRA and federal preemption.
And as such, has that caused problems, for example, with respect to Arizona, where Arizona currently basically operates two separate systems, where they register individuals checking proof of citizenship for state and local elections, but they, on the federal side, do not, because of this barrier put in place prohibiting them, in essence, due to the court's interpretation of NVRA, prohibiting them from being able to check citizenship. Is that an accurate statement?
Yes.
And what we're endeavoring to do here, which obviously was debated and amended in committee, if I'm correct, I believe that the ranking member's amendment was offered in committee and failed 6-1.
That's accurate.
And there was a significant number of Democrats not present at that hearing.
6-1 indicates that.
Right. And so that amendment was offered. There was, at least debate with the one Democrat who was present, given that there were no other Democrats present at the hearing. But with respect to what we're trying to do with this legislation, we're trying to first make sure that barrier is brought down, but go a step further, given the extent to which we now have, and I would ask the chairman if he agrees with me, increasing evidence that there are jurisdictions seeking to register non-citizens to vote, at least at allegedly the state and local level, But wink, wink, nod, nod, don't worry, we'll never have those registrants being involved in federal voting. But the truth is, there's an expansive view in Oakland, San Francisco, New York, tried to happen here in the District of Columbia, right? We had a vote on that here in the House. So would the gentleman agree, what we're seeking to do is to do what many states do right now and attempt to do, but are prevented because of the Supreme Court opinion, require a documentary proof of citizenship to be able to vote in federal elections, to be able to address this problem?
Yeah, I mean, this is exactly what we're trying to do with this legislation, is allow states to have that opportunity to provide documentary proof of citizenship. In fact, require it. And I think you correctly note this administration is working aggressively to roll out a secretive plan on voter registration. In fact, they put forward an executive order 14019 requiring every agency to put forward a strategic plan as to how they were going to help get out the vote in effect. And they won't provide us with that strategic plan. I've subpoenaed the 15 administration officials to get that, because I think taxpayers deserve to know how their taxpayer dollars are being used. So you have this administration working in secret to try to roll out and utilize the federal government to get a get out the vote operation. We're, in contrast, just trying to make sure that U.S. citizens are the ones who are voting in U.S. elections.
Gentlemen, aware with respect to the problem we're identifying that our colleagues have suggested does not exist, that there is a significant amount of evidence of people who are non-citizens voting in our elections. A study, for example, professors at Old Dominion University and George Mason University from 2014, finding that non-citizens participate in U.S. elections, and that this participation has been large enough to change meaningful election outcomes, including electoral college votes. You aware of that study?
Yeah, yes, and we've looked at a number of examples in our committee hearing. I actually think one of the most pertinent examples is the congressional review of the 46th congressional district race in California in 1996, where they actually did a retrospective analysis on who voted. And it was documented that 624 non-citizens voted in that election. And if we extrapolate that across 435 House districts, or you just look at it at a House district where we know often House races are determined by less than 600 votes. We have a colleague from Iowa where it was 6 votes. And so there is documentary proof of non-citizens voting in U.S. elections, and this is why your legislation is so essential.
And it's true that there are multiple states in which in the electoral college process are states that have been determined by thousands of votes, right? I mean, 10,000 votes in Georgia, less than that in certain other states, 15,000, you know, so those votes are meaningful.
In my home state of Wisconsin, a landslide is 20 or 30,000 total votes. I mean,
Right.
a few thousand votes here or there can swing any battleground state.
The study that I quoted from Old Dominion George Mason estimated that 6.4% of non-citizens voted in the 2008 election, which would represent 1.2 million non-citizen votes cast. I do want to, with all respect, correct my friend from South Carolina. There was a report out of Texas of a number that he quoted about 95,000. He said almost 100,000. That number was later corrected to be 25,000. There was a mistake in the counting. But for the record, there were 25,000 in Texas in that report. Virginia last year removed 1,481 voter registrants for non-citizen status. North Carolina conducted a study in 2014 with over 1,400 registered voters. In 2024, an audit carried out in Ohio flagged 137 individuals. There's list after list after list. And I would note that there are examples, I assume my colleague is aware of, certain of our Democrat colleagues, one in particular in January 2024 saying, quote, "I need more people in my district just for redistricting purposes," in a direct response to the border crisis. Does the gentleman remember that
Very much so.
statement? In other words, the idea that there's not a problem is belied by the facts. The idea that there's not a problem with respect to our border is, of course, belied by the facts. And I'm always entertained by this notion that, well, it's illegal already. Why do you guys need to do this? Well, number one, well, then what are you worried about? Number two, if it being illegal solves the problem, then the fact that it is illegal for people to enter the United States, you would think would solve this rather enormous problem of millions of people being released into the United States, correct?
That's spot on.
Yet here we sit. I would note, in addition, that we've got some people raising issues about that this will cause a burden to those who wish to vote for citizens. Is the gentleman aware is that the list of items that we put in the legislation mirrors numerous existing state laws. For example, that bastion of wing nuttery, the state of Massachusetts. The language that we put in the bill is very similar to that which is put forward by the state of Massachusetts. The gentleman agree?
Yep.
And the documentation that we talked about, we have provisions replete in the bill to allow people and allow administrators to create mechanisms, for example, for women, spouses who change names, individuals who want to be able to provide a different route to be able to provide evidence if they run into a barrier with, coming up with a passport or a real ID, or in the military examples. Is that correct?
The EAC opportunity to provide that guidance to states is a key component of the bill.
And a last, I think, important point, which is the extent to which this is very inherently a role for Congress and a federal issue. The extent to which the Constitution very much contemplates that, of course, the time, place, and manner of holding elections, shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, right? Then you follow the jurisprudence and you figure out, okay, there's some debate about whether the how versus the who, that question which the court has raised. In this case, of course, the Constitution contemplates that the naturalization clause puts Congress, frankly, the court has placed it maybe even higher than intended, Congress at the full center of making determinations about all things naturalization. So the combination of the Elections Clause and the Naturalization Clause, combined with the numerous amendments, the 15th, 19th, 24th, 26th, all referencing, quote, the right of citizens of the United States to vote, I think clearly demonstrates the power and the duty of Congress to act in this case. Would the gentleman from Wisconsin agree?
I agree.
And so at the end of the day, we have the power, we have the duty, we have legislation to resolve a very real and growing problem. We have 80+% of Americans wanting us to solve said problem and guarantee that only citizens vote. We have put forward legislation to do that under the powers that we have under the Constitution. We are solving a real barrier to states being able to conduct their duty to do this and providing a mechanism for federal elections only, a requirement that it be consistent across the country. Is that a fair characterization?
It's fair.
I yield back.
Thanks, gentleman. Gentleman yields back. The gentlelady from New Mexico is recognized.
Thank you very much, Mr. Chairman, and good to see you. I very much enjoyed my time on House Administration and on the Subcommittee on Elections. Boy, what a difference there is when you change from Democrats to Republicans, right? You were not there, Ranking Member, but the chair and I sat through many a hearing when we talked about how wonderful it was that we had actually had an increase in voter participation in 2020. And my thought was, why don't we get very excited about that and make it easier and make sure that more Americans vote, right? Because that is democracy. We just celebrated the 4th of July. We should make it easier for American citizens to vote. And instead, we have this bill, which would make it harder for American citizens to vote. So you wonder why. Is it because the 2020 general election featured both the most Americans voting, but the Republican candidate lost? Because this bill goes after the communities that helped President Biden win. For example, polling of military personnel in 2020 showed that they didn't trust Trump as commander-in-chief, and many were shifting from voting Republican to voting for Biden. Mr. Chair, I'd like to enter into the record the 2020 NBC article. Trump says the military will vote for him, but he lost their support long ago. Trump treats the armed forces as just another entity he can manipulate for political purposes. That's alienated the troops and the top brass alike, close quote.
Without objection.
So this bill would make it harder for military personnel to sign up and vote. Our men and women in uniform, they give up so much. They travel, they're away from home, it's not easy to vote. And you touched upon this earlier, Ranking Member, but what's your reaction when you see Republicans making it harder for military to vote? And do you see any good reason in treating our military that way?
I can, I think I articulated the barriers that would exist, and it's certainly not only for the military, although it does raise a number of questions, but just the kind of burdens that would now be placed on people simply to register to vote when there is scant evidence that there is any concern, despite what people say, there's not a concerted effort that I'm aware of to have non-U.S. citizens register, because frankly, you'd be putting them in harm's way. Just the registration is illegal, and certainly voting is subject to criminal penalties as well as deportation. It simply doesn't happen. In fact, the George Mason study, which was referenced, has been completely debunked by experts in the field of statistical survey data, and it's been debunked by so many different experts. And in the decade since the report was published, its authors have not published a defense of their research work, and nothing has made it through a peer review that survives any serious scrutiny. So there is, despite, anybody could put out a paper, I guess, but when it's debunked by experts who looked at the survey data, I think it begs the question. And when you don't, and when you don't rebut that criticism, I think that says a great deal. But this, to your point, and I think this is a really important point, which is the problem in America is not too many people voting, it's that participation still lags behind. I mean, when half of the eligible people in an American election vote, register and vote, I think that says a great deal. We should be making this easier for people to access the ballot, not more difficult. And frankly, the amount of documentary evidence that this bill anticipates is extraordinary. I doubt that every Republican in the House has read through the amount of barriers and hurdles you would now have to register to vote.
Right, and when we're talking about military participate at a lower level anyway, right? They put their lives on the line, but because it's so difficult, they participate at about 27% points lower than the regular American voter. And you're going to make it harder for them? Really? So Native Americans, right? Native Americans are also targeted, in essence, by this bill. And we know that Native Americans in Arizona helped President Biden win that state. The Arizona law that was attempting to depress that vote, one of the court cases I remember said it was like us taking a scalpel to the communities that helped fuel President Biden's win in Arizona. Native Americans and Latinos. You were in Arizona. You were in New Mexico, weren't you? So tell us some of the stories that you heard.
Well, look, I did, thank you for that. I released just today a report on voting for Native peoples, barriers and policy solutions. Not only did I spend time in Arizona and New Mexico meeting with tribal leaders and tribal members, but staff has spent a great deal of time traveling around the country. There are significant barriers to tribal residents voting, which are detailed in the report. I would encourage people to read it. I mean, these are the first Americans, and they have been treated, despite the Citizenship Act, which is, we celebrate its 100th passage and enactment, still enormous barriers. This will only make it more difficult, as you know, and tribal IDs will no longer be accepted because they don't meet the standard in the new bill in terms of registration.
Right, so Native Americans, the first Americans, right, who are clearly citizens, who didn't get the citizenship until about 100 years ago, and we're still making it hard? We are still making it hard? Mr. Chairman, I'd like to enter into the record the report.
Without objection.
So, it is just outrageous that we would do that. And then it hurts me a lot. I represent a rural district. And rural districts, like voting absentee and voting by mail is important in rural areas. In November, the snow comes, and a lot of people like to register and participate by mail and absentee. And it makes sense, right? And this will make that harder. Is that correct, Ranking Member?
Well, excuse me, it absolutely would. In many states, mail-in voting has been the standard for decades and decades without any alarm bells ringing that there's been any fraud involved. Arizona, 85% of voters vote by mail. States like Oregon and Colorado have long traditions of mail-in voting. If you're a rural resident in the United States, very often long distances between you and polling places. So mail, telephone, the internet, wherever possible, are the ways that you conduct your daily life. These will make most of these activities impossible as it relates to voting. So it just makes it, again, more difficult. It would prevent rural Americans from registering to vote by mail or online, requires an applicant to present documentary proof of citizenship in person at the office of an appropriate election official. That's in the bill. It would force millions of rural Americans who have registered to vote online or via mail to travel significant distance to present documents to government officials, something they currently have to do, they don't have to do, and have not had to do for decades now. And I do want to mention, 48% of Americans don't have passports, one of the forms of citizenship that the bill suggests. This is an insurmountable barrier to many people who would try to register for the first time, and it would burden rural voters who often have limited access to the types of government offices that you would find in urban settings that would help them access the documentary proof of citizenship, like passport services. So even if you wanted to get a passport, it's difficult to get to the offices. So it is voter suppression that targets rural Americans, hurts military personnel, hurts women who have changed their name as a result of marriage. I mean, students, you name it, the list is long of people who would be burdened by these new requirements.
And when we look at what was the coalition that led to the victory for Biden, these are the kinds of people, and this is the kind of voting that led to that, and they are under attack. You know, this week of, July 4th and celebrating freedom and democracy, democracy does not exist without strong voter participation, and it's shameful and unpatriotic when Republicans take aim at voter participation. Is there anything else you'd like to add, Ranking Member?
Well, just that, again, our goal ought to be to make sure every single American, every citizen in this country has access to the ballot. Sadly, too few do, too few participate, and putting more burdens on them is unacceptable if our goal is to make sure every single American is heard at the ballot box and that their votes count. That's what we ought to be focused on. I think that's what the Congress ought to be doing. That's what the Freedom to Vote Act does. That's why we offered it as amendment. Sadly, it wasn't deemed in order under the closed rule, but we'll keep fighting for it.
Right. And the reauthorization of the Voting Rights Act used to be bipartisan. It passed 98-0 last time. And now Republicans have abandoned the Voting Rights Act. And that is once again in this month of celebrating our anniversary as a country that is founded on democracy. It is both shameful and unpatriotic. And I oppose this rule and bill. And with that, Mr. Chair, I yield back.
Gentlelady yields back. Chair thanks the gentlelady. Recognizes the gentlelady from Indiana for questions. And I hope you will give Chairman Stile a chance to respond to some of this.
Sure. Actually, I would love for Chairman Stile to respond, and then I'd be happy to go into some of my questions.
Well, I think what's so important is that we're making sure that people are participating in our elections. And what we have seen time and again is the integrity in our elections increase. People are more likely to participate. It's actually the reason when we introduced a series of election integrity bills that we did that in Atlanta, Georgia. Because I think a lot of people remember the lies that were spewed about the election integrity legislation in the state of Georgia. In fact, President Biden made statements that even the Washington Post called out is earning Pinocchios for being so misleading to the American people about what the state of Georgia was doing when they were implementing their voter integrity legislation. You may recall Major League Baseball bought into those lies. They moved out the All-Star game out of Atlanta. But what we can do now is go back and look at the empirical data of the 2022 election. And what we saw is high voter participation, and the University of Georgia did a robust study analyzing the elections after they took place. And what the University of Georgia found is that people actually were very supportive of how the elections were run, and across all key demographic groups, in particular blacks in the state of Georgia, had a very positive view of how those elections operated, in direct contrast with the misleading statements and, in fact, lies by some on the left of what the bill would actually do. And so what we see time and again, and the empirical evidence shows this, is that when we actually increase the integrity of our elections, more people are likely to participate, and that's a good thing. And so when we look at this legislation, this is an opportunity to further enhance the integrity of our elections and actually increase total voter participation of U.S. citizens.
Thank you. On Joe Biden's first day in office, he issued a myriad of executive orders. Some of those I will highlight here. One, repealed a previous executive order by President Trump, which had secured the southern border, took all that away. All of those policies that were keeping the border secure were undone by Joe Biden on day one. Another executive order on day one stopped funds from being directed toward border wall construction. And then another executive order allows for non-citizens to be counted in the census data for electoral college and congressional apportionment. Now, under President Biden, we've seen millions of illegal aliens being released into the interior of the United States, 2 million known gotaways. The Biden administration's failure at the southern border has been well documented. It is a complete and total disaster. In addition to the executive order President Biden signed on day one, he also made an executive order that said, it was the executive order on promoting access to voting that requires federal agencies to expand opportunities to register to vote. So all of these things are pointing in a direction, at least pointing in a direction that I believe is wrong for the United States of America, and it undermines our system of democracy, which is why I support the SAVE Act. The failure to secure the southern border is one thing, but in what we've heard today in this committee and from our colleagues on the other side of the aisle is that they unbelievably think that we're somehow diminishing the vote or the opportunity to vote of American citizens by requiring proof of citizenship for someone to vote. How does that, Mr. Stile, Chairman Stile, does it diminish the opportunities for U.S. citizens to express their viewpoints at the ballot box by allowing non-citizens to vote?
Every non-citizen that vote cancels out the vote of a U.S. citizen. And so when we look at the instances of non-citizens voting, and again, there's ample evidence of non-citizens voting in U.S. elections, each person who has voted illegally as a non-citizen is canceling out the vote of a legal U.S. citizen. And that's why there should be such concern. And then you correctly note what this administration is doing. I think that's really important, Ms. Houchin, is you correctly lay out that on day one, the Biden administration comes in and unwinds the secure border policies of President Trump, and we see a massive rush of individuals enter the country illegally and then enter throughout the country. You combine that then with the president's executive order, which you also noted, 14019, which is weaponizing federal agencies in the engagement of a partisan get-out-the-vote effort. And in fact, inside that executive order, the administration required each federal agency to come up with a strategic plan. But they won't give that strategic plan to me or to the American people, and that should be incredibly concerning, that this administration has weaponized federal agencies to develop a secretive scheme to use federal agencies to drive forward a partisan agenda as it relates to elections. And you couple that with the open border policies of this administration, it should give great concern to Americans across the board. And when we look at an opportunity here to simply say, what we want to do is make sure that U.S. elections are for U.S. citizens, to make sure that we're not allowing the NVRA to be used as a block from checking whether or not an individual is a U.S. citizen, this legislation gives us an opportunity to make sure it's U.S. citizens who are participating in U.S. elections.
Thank you. And it's interesting that not only do our colleagues on the other side of the aisle not want to require U.S. citizenship as a matter of who should be voting in this country, but they also do not support voter ID laws to make sure that it is one person, one vote. Chairman Stile, the ranking member has made some claims that requiring proof of citizenship creates a hardship for citizens. I'd like you to just, and you've done this somewhat, but I'd like you to just provide a counter to that. In your view, articulate why the ranking member is wrong in his claim that there's some sort of a hardship for citizens simply by requiring them to prove that they're U.S. citizens to vote.
So
to
we
register to vote.
offer a series of opportunities for an individual to provide documentary proof of citizenship. So obviously, the passport, it was referenced by my colleague, that is one opportunity. We could look at Real ID for those Real IDs that have U.S. citizenship denoted on it. More states should take advantage of that inside Real ID so that it can be utilized. But again, today, under current law, states aren't allowed to even validate the individual who checks the box to say they're a U.S. citizen is a U.S. citizen. So many states didn't put that in the requirements. A huge opportunity when we clean this up, after this bill passes, to make sure that Real ID has that opportunity where states can then quickly validate that. That's going to be a huge opportunity. And then we look at the EAC to put forward guidance to states to address some of the concerns that have been brought up, to make sure that an individual who has a name change, et cetera, has that opportunity to not be burdened as they go to vote. But again, under current law, states aren't even allowed to review whether or not an individual is a U.S. citizen. This bill not only gives the opportunity, but requires it, which I think is essential to make sure that it's U.S. citizens that are participating in U.S. elections.
Well, thank you. Thank you for your leadership on this issue of election integrity. It's extremely important, and I yield back.
Gentlelady yields back. Chair thanks the gentlelady. The chair recognizes the gentleman from New York, Mr. Langworthy, for questions.
Thank you very much, Mr. Chairman. I'd also like to thank my colleague on the Rules Committee, Representative Roy, for leading this legislation, the SAVE Act. As a member of Congress from one of the states that has recently attempted to allow non-citizens to vote in our local elections and has simultaneously pursued sanctuary policies that have led to a flood of illegal immigration, I am very proud to be a co-sponsor of this bill that seeks to protect a key institution of our democratic system amid an unprecedented crisis on our southern and our northern borders. Our colleagues on the other side of the aisle, however, don't seem to care about the real and the documented threat facing the security of our elections here. They will say, and they have said, that the number of illegal aliens who have attempted to vote in our federal elections is small compared to vote totals. But Chairman Stile, in your view, how high do the numbers of non-citizens illegally voting or attempting to vote in our elections have to get in order for Congress to take action? Is there some kind of magic threshold?
There's no magic threshold, and I would note that we have done a series of hearings that have shown where non-citizens have voted in numbers that could have a significant impact or determinative impact on federal elections.
Yeah, I mean, the radicals in the New York City Council tried to pass a bill that would allow a separate set of books for non-federal elections versus federal elections, and it was struck down as unconstitutional in New York State courts under the New York State Constitution. But I agree with you. The acceptable threshold for non-citizen voting in our federal, our state, and our local elections should just be 0, period, end of story. This is a right and privilege of American citizens, and it should be protected as such. And Chairman Stile, isn't it true that we can't trust the Department of Justice to go after non-citizen voting or even to try to address the problem of non-citizen voting?
They've shown no prioritization of citizenship and non-citizenship voting.
And I think that should be incredibly troubling, given the fact that we have like 10 million people here illegally wandering around the country right now, all over the United States. It's a 50-state problem. It's especially a problem in my home state of New York, and it just boggles my mind that this isn't something that we can pass on a suspension to safeguard our votes for only citizens of the United States of America. But I completely agree with you. If the Biden White House isn't even willing to say that there's a problem, how can we trust the DOJ that they're even going to do anything about it? I strongly support this legislation before us today. It's a simple, straightforward measure that the vast majority, 3/4 in fact, of Americans support as well. And I yield back, Mr. Chairman.
Gentleman yields back. Chair thanks the gentleman. Chair recognizes the gentleman from Georgia for questions.
Thank you, Mr. Chairman. I'll be brief. I'll just say I went to the pharmacy to buy Sudafed the other day, and you know what? I left my wallet in my truck, and they had to go back and get it. You have to have an ID to even buy Sudafed in this country. I think that We need to have voter ID laws in this country, and I think that we need to be able to make sure that the person on the ID is constitutionally, legally, the person they say they are and eligible to vote as a U.S. citizen. I think it should be limited to U.S. citizens. That's my opinion. Mr. Style, you brought up the Georgia law. I'm from that great state. I listened to all the hee-hawing and everything else, and MLB moving, you know, the game and everything else. And you know what happened after that law passed? The state of Georgia elected a Republican governor and a Democrat U.S. senator. And there were no questions about the integrity of the ballot after Georgia passed that law. And I supported that law, and one of the reasons I did is because there were over 1.2 million votes in the state of Georgia cast with no voter identification, none whatsoever. And if you look back at the historical numbers, the mail-in ballots, and I realize we had the COVID uptick, but mail-in ballots had typically been a very small total number, maybe 200,000 total for presidential elections. And in COVID, it went to over 1.2 million. I think my state legislature responded. And while Major League Baseball bought into all of the lies told about the law, ultimately the law elected a Republican governor that I voted for and a Democratic senator that I did not. And so I think this is a good law. I don't have any questions for, you know, the author or the people that are presenting, and I look forward to voting for it on the floor.
Chair, thanks, the gentleman. Gentleman yields back. I want to thank our witnesses for the thoroughness with which they've approached this important issue, and the witnesses are excused. Thank you. Thank you. And I would like to welcome our second panel, Chairman David Valadeo and Ranking Member Espaillat from the Committee on Appropriations. Chairman Valadeo, I welcome your testimony.
Thank you, Chairman Burgess, Ranking Member McGovern, members of the committee. Thank you for the opportunity to testify with regards to the Legislative Branch Appropriations Bill for fiscal year 2025. The recommendation for the fiscal year 2025 Legislative Branch Appropriations Bill provides $5.546 billion, excluding Senate items, which was traditionally left to the Senate to determine. This is a 3.5% increase from fiscal year 2024 enacted House levels. The bill supports the legislative branch as an essential branch of government that is open to and works for the American people. Regardless of what side of the aisle you are on, we can agree that our greatest duty is to our constituents. This bill funds our ability to advocate on their behalf. This bill invests in the resources necessary to provide robust oversight of the executive branch. It also includes modest increase to ensure the safety of the Capitol complex and the work of the Capitol Police, as well as the institutions that support our work, such as the Library of Congress and the Government Accountability Office. I appreciate Ranking Member Espaillat's cooperation and support through the formation of the bill, and believe it balances the legislative branch's capacity to effectively serve the American people in a fiscally responsible manner. I request a favorable consideration and look forward to your questions. Thank you, and I yield back.
Chair, thank you, gentlemen. Ranking Member is recognized.
Thank you. Thank you, Mr. Chairman, Chairman Burgess, and Ranking Member McGovern. Thank you for having me today and giving me the opportunity to discuss H.R. 8772, the Legislative Branch Appropriations Act of this coming year. Before I discuss the bill, let me take a moment to thank my colleague, Chairman Valadao, as well as the subcommittee staff who, yes. Sure, is that better? Before I discuss this bill, let me take a moment to thank my colleague, Chairman Valadao, as well as the subcommittee staff who work daily to ensure the legislative branch has the resources it needs to support America and its people. The fiscal year 25 legislative branch bill allocates $5.5 billion, a 3.5% increase from fiscal year 24 enacted levels. As mentioned by the chairman, the bill funds essential agencies like our Capitol Police, the Library of Congress, Government Accountability Office, and supports modernization, infrastructure, and security initiatives. I am sure we can all agree that these are all good things. And as I said during the full committee markup, the problem with the bill is its unnecessary, harmful policy riders. These harmful policy riders undermine diversity program, LGBTQ rights, and environmental efforts. Diversity is the young women that are stenographers. Diversity is Miss Gallant. I am diversity. Many of the members of this committee are also representative of what diversity is. And so I am sure that we need to work harder to ensure that government looks like the people we serve. Instead, we should focus on restoring the Office of Diversity and Inclusion, providing work eligibility for DACA recipients, and reducing our environmental impact. This House and the many agencies that make up the entire legislative branch of government should make every effort to be reflective of all the people that exist in this great nation we serve and the many districts members represent. Mr. Chairman, the legislative branch bill should represent a collaboration between two parties. We come here to work together, and our place of business must be a role model for a more equitable, inclusive, and positive working environment. Instead, the bill includes provisions that are hurtful to many Americans, some of which are the staff that support these great institutions. How can we bring this bill to the floor and work along the staff that this very language of the bill potentially offends? I can and don't agree with these divisive ideas. For that reason, I cannot support the bill. Thank you, Mr. Chairman, for the opportunity, and I yield back.
The gentleman yields back. Chair thanks the gentleman. I thank both of our witnesses. You've done such a spectacular job. I have no questions. I'll recognize the gentlelady from Pennsylvania for questions.
Thank you. I share the ranking member's concern about the attacks on diversity, equity, and inclusion principles. Like the previous appropriation bills to come before this committee this summer, this legislative branch bill is full of partisan policy riders that are going to make it a non-starter, and then we end up in the same situation we did last year. This is a weird obsession with DEI programs, although I suppose it's not a surprise given the fact that the Republican nominee for president refers to certain jobs as black jobs, but I don't think they should be using the legislative branch appropriations bill to wage their culture wars. Congress works better, and the country benefits greatly from a diverse pool of staff that reflect the nation we're here to represent. So we've just seen bill after bill where House Republicans have gone to great lengths to block, limit, or prohibit efforts to improve diversity among congressional staff, federal employees, and in prior bills that we've seen in the VA, in the military, et cetera, despite demonstrated evidence of discrimination in all of these sectors. So among the other harmful provisions in this bill, it basically creates a license for people and organizations, including those that receive taxpayer funds, to discriminate against LGBTQI plus people under the guise of religious liberty, and I absolutely have to oppose that. By politicizing the appropriations process, Republican lawmakers are blatantly ignoring the absolute human right of our diverse neighbors and colleagues to live their lives free from discrimination. These deeply regressive views have unfortunately been mainstreamed into today's Republican Party platform, and it's woefully out of step with the majority of Americans who love their neighbors, who love their colleagues, who want people to be able to live in peace and harmony in their communities. So our government should be working to end discrimination and encourage a workforce that represents America's diversity instead of encouraging discrimination and isolation among those communities. So I yield back. Thank you.
Chair thanks the gentlelady. Gentlelady yields back. The gentlelady from Minnesota is recognized for questions.
Thank you, Mr. Chair. I just kind of wanted to unpack some of that just because I don't oppose religious liberty, but I support this bill. I had a different line of questioning, but after Ms. Scanlon was talking, I'm wondering where all this is, where all that you talked about is in this bill, because I don't see it, and it doesn't stop anyone from, being friends with their neighbors, or doesn't stop diversity. It simply doesn't use taxpayer dollars to force it, and to create programs that are in some ways unnecessary. And so I won't go down that too much, but I did want to ask a little bit about the returning the MRAs and to go against the deficit, to go against deficit reduction. And I was kind of curious if you had an estimate, maybe in the past, of how much money had been returned and what had happened to it previously.
So I'll have to get back to you with the actual estimate of the
that's
previous
okay.
numbers. But as far as the MRA back to Treasury, the money does sit in an account for a period of time until all bills have been cleared, because obviously there is sometimes a late bill that will come in from a contractor or something that we deal with in our offices on a regular basis. But once we get to that period of time that closes out, the money does then go back to the Treasury to offset. It just takes that little bit of time from when the fiscal year ends to the clearing point, and then it allows. It's about a 2-year point of
And
time.
so currently, it's just going back to the Treasury, and this way, it would be earmarked for the deficit reduction.
Yes, so when we pass a bill and the bill ends or the fiscal year ends September 30th, we start the new fiscal year if we do our jobs right. Obviously, we struggle with the CRs and the whole process. But once we start with the new fiscal year, the dollars from the old one, from the previous funding bills, will sit and wait and give that 2-year period, and then it'll go back to the deficit reduction. But we do have to make sure all those bills are cleared out first.
Yeah, I understand that, and I appreciate that because obviously there's a lot of issues facing us with the deficit, and so whatever we can do to help, and I know that they are turning back funds already.
And I just want to be clear that the MRAs, since there have been MRAs, this has been a provision that's been in all funding bills since MRAs were started. So it's not a new thing, but it's something that is important for our constituents to know. So I appreciate you bringing that up.
All right, well, thank you, and thank you for bringing the bill forward.
Thank you.
Yield back.
Gentlelady yields back. Chair thanks the gentlelady. The gentleman from South Carolina is recognized for questions.
Thank y'all for coming. I like this, Dave, appreciate your work on it. The increase in the budget, if anything should have been cut, is IMRA. We got way too much money. And the only thing to get this country back on track, I hate we're doing an increase without offsets. Getting this administration to do any kind of offsets, building walls in other countries, studying fish hatcheries in other countries is ludicrous. I like the Capitol Hill Police, the money for that. I appreciate your work on this, and I will be supporting. I will be advocating for lower dollars, though. Thank you.
Does the gentleman yield back? Chair thanks the gentleman. The gentleman from Georgia is recognized for questions.
Thank you, Mr. Chairman. And I want to bring up an issue, and I feel sure it'll be written about after I bring it up. But the 1989 Ethics Reform Act governs the pay of members of Congress. This act has already been to court. John Boehner sued in Boehner v. Anderson to stop the annual cost of living adjustment that is to be given to members of Congress in the 1989 Ethics Reform Act. That 1989 Ethics Reform Act, that provision of it has never been changed, is my understanding, has it?
I'm not sure.
It has not been changed. The law today is that members of Congress receive a cost of living adjustment, and that is in exchange for the fact that we cannot have outside income. That it's specifically, the 1989 Ethics Reform Act is specifically written that way. Members of Congress cannot have outside income beyond a certain threshold. It's about $26,000. And in exchange for that, members of Congress are to receive a cost of living adjustment. That is the intent of the law when it was written in '89. It is still the law. And I'm not asking either one of you to comment on it, but I will tell you, when you take that in conjunction with the 27th Amendment to the Constitution, which is very clear, it doesn't say you can't raise pay. It says you can't vary pay. And vary means you can't raise it and you can't lower it. And I realize the politics of it is ugly. I realize it's a cost of living adjustment. The press portrays it if it's a pay raise. But I just want to make this statement, Mr. Chairman. I believe our democracy, I believe this House of Representatives and the U.S. Senate needs people that didn't necessarily win the Mega Millions or are worth $100 million when they come here to be able to continue to serve. And for 15 years, the cost of living adjustment has been withheld. I think it's a constitutional violation. It is in court right now. I hope the judge will simply look at the facts of it. I expect as a federal judge that they will. But I'm just telling you, if you want to stop the cost of living adjustment for members of Congress, you need to change the 1989 Ethics Reform Act. Congress has never changed that, and I believe that the withhold of the cost of living adjustment for members of Congress, while it is no doubt extremely popular to say no pay raise for members of Congress, is unconstitutional because it violates the 27th Amendment and the 89 Ethics Reform Act. I'll also tell you, I think it's very damaging to our democracy that we are creating a scenario under which middle-class Americans cannot afford to serve in Congress. And if you look at the people who are leaving, if you look at the people who are leaving this institution voluntarily, they are, for the most part, exceptionally good members that come out of middle-class America. And I think it's just damaging to this democracy and this institution to create a scenario in which middle-class Americans can't serve. And when you go 15 years without a cost of living adjustment, that's the end result of it. With that, Mr. Chairman, I yield.
Gentleman yields back. The chair thanks the gentleman. I would just note that I agree with his observation on members who are leaving. There are some exceptionally good members who are leaving, and they represent the best of middle-class America. Seeing no other members asked to ask questions, we thank you for your discussion today, and this panel is excused. I'd like to welcome our third panel, Chairwoman Dr. Virginia Fox and Ranking Member Bobby Scott from the Committee on Education and the Workforce. Dr. Fox is still en route, so Ranking Member Scott, pending her arrival, we'll hear from you first.
Thank you, Mr. Chairman. Mr. Chairman, good afternoon, Ranking Member McGovern and members of the Rules Committee. I'm here to speak in opposition to HJ Res 165, the Congressional Review Act resolution to repeal the Biden-Harris administration's Title IX rule. The administration's final Title IX rule does...
Continue.
I'll suspend.
No, please continue.
Okay.
No, please, go ahead.
Okay. The Title IX rule does three things. First, it protects against all sex-based harassment and discrimination. It reverses arbitrary provisions in the Trump-era Title IX rule that allows colleges and universities to turn a blind eye to sex-based harassment and discrimination based on where it was happening. If it didn't happen on campus, for example, they don't have to pay any attention to it. It prevents schools from ignoring harassment and discrimination by placing a duty to report possible discrimination on more school employees. Consistent with the Supreme Court precedent, it recognizes that discrimination based on sex includes discrimination based on sexual orientation and gender identity, fully protecting LGBTQIA+ youth from discrimination in educational settings. Second, it promotes accountability and fairness in how schools respond to and discipline sex-based discrimination. This will mandate that schools deal with complaints in a timely manner and ensure a fair and transparent process, as opposed to the previous rule that allowed schools to deal with these cases at their own pace so long as they were not deliberately indifferent. New rule also outlines the specific standards, rules, and processes that schools must implement to bring their grievance procedures into compliance with the rule. Finally, the rule empowers students and families to exercise their rights under Title IX. Administration's Title IX rule explicitly protects complainants from retaliation for seeking to have their Title IX rules enforced. Further, the bill ensures survivors and the accused to have access to supportive services as needed. In sum, the administration's Title IX rule protects all people from sex-based discrimination, including women, girls, LGBTQ individuals, and survivors of sexual assault, while maintaining the rights of the accused and mandating equitable processes for resolving complaints. This rule will uplift and empower these individuals to speak up for themselves and make our community safer. Unfortunately, this important discussion on non-discrimination has been marred by consistent misinformation and attempts by Republicans to weaponize women's rights and scapegoat the LGBTQIA+ community for imagined crimes. I would hope that every single person believes that that restrooms should be kept safe and private. It is illegal for anyone to enter a restroom to harm someone. Unfortunately, my colleagues have invented a narrative that portrays trans individuals as criminals attempting to enter restrooms to harm young girls, but that simply is not supported by evidence or data. Transgender people want the same things everyone else wants: safety, comfort, and privacy. We must work to protect the transgender community from discrimination, not further a false narrative that exacerbates and encourages prejudice against innocent people. Lastly, I want to point out that this CRA is extreme. It is in the unlikely event that the joint resolution passes both chambers and is signed by the president, it would prohibit any future regulations that are substantially similar to the current rule. This means future administrations would not be able to regulate this topic, including providing protections for sexual assault survivors and protections against discrimination on the basis of sex, sexual orientation, or gender identity in federally funded schools. If we really care about protecting women, we would spend less time obsessing over which bathroom to use and more time defending women's rights to reproductive health care, supporting proposals to make child care more affordable, and finally, fighting to close the gender pay gap. So I thank you for the opportunity to speak in opposition to the joint resolution, welcome your questions, and yield back the balance of my time.
Gentleman yields back, Chair. Thanks. The gentleman, the ranking member, the chairwoman of the committee is now recognized, Dr. Fox.
Well, okay, well, I'll try that one. This one doesn't seem to be working. Thank you, Mr. Chairman, and thank you for allowing us to come to the Rules Committee today to present HJ Res 165, CRA resolution to nullify President Biden's Title IX rule. We recently celebrated the 52nd anniversary of Title IX, which protects women and girls from discrimination in schools, colleges, and universities. 52 years ago, President Nixon and a Democrat-controlled Congress knew the biological differences between a man and a woman. 52 years ago, women were given equal opportunities in education under the law. The science and innate biological differences between a man and a woman have not changed. Shockingly, the partisan politics have. The Biden administration has decided to appease a radical left-wing agenda rather than uphold the equality and safety of women and girls. The Biden administration's final Title IX rule allows men to intrude into women's spaces and strips away athletic and scholarship opportunities, jeopardizing the equality originally provided for women's sports and activities and paralyzing the safety of single-sex private spaces for girls. HJ Res 165 is a Congressional Review Act, CRA, resolution to nullify the Biden administration's Title IX rule. The Education and Workforce Committee has talked a lot about 52 years of progress for women's sports and schooling, but I want to leave you with one more comment. Less than 1/100th of a second, that is, by how much former NCAA swimmer Riley Gaines lost to a biological man during a swim match. Miss Gaines will never get that 1/100th of a second back, but nullifying the administration's Title IX rule will return 52 years of opportunities and fairness to women and girls in schools across the country. I urge the passage of the CRA resolution to correct the Biden administration's injustice toward women and girls and to protect the integrity and safety of the schooling and sports of the next generation of America's women leaders. And with that, I yield back.
Gentlelady yields back. Chair thanks both of our panelists for their testimony. Let me just ask you, Dr. Fox, this rule came from the Department of Education, and how would the schools actually implement what they're asking? What type of burden are we placing on the schools themselves?
Well, what it's going to do is going to say to the schools that they have to treat biological males who say they feel like females as though they are females. It's an overstep by the federal government. We know that already that 3 different federal courts have ruled against the administration's regulation. I think that says more than anything else. One judge called the regulation, quote, an abuse of power, and argued that the regulation subverts the purpose of Title IX. I agree with that. Nobody in his or her right mind thinks Congress intended Title IX to protect the rights of boys to shower with girls, but that's exactly what this rule does. It also undermines protections, not only undermines them, but decimates them. The rule eliminates the right of schools to prevent males from intruding in women's private spaces. It eliminates the right of schools to ensure that women can use the bathroom, change clothes, or even shower without men present. The rule also eliminates female-only sports. That was mostly what Title IX was all about when it was passed, to give women and girls equal opportunity in sports. And what this is doing, basically, is wiping out opportunity for women. It's really a puzzle to me, because Democrats, as I said, this was signed when Democrats were in control of Congress. President Nixon was president. It was a bipartisan issue in those days. Now, it appears that though Democrats want to erase women by allowing men to compete. And we've all seen episodes other than Riley Gaines' episode where men have competed against women. And we know men and women are different. And men have biological advantages over women when it comes to sports, when it comes to lots of other things. And it really is going to harm women.
Well, thank you for your work on this. I agree with you completely that it does subvert the purpose of the original intent of Title IX, and I hope that you're successful with getting this passed. I'll recognize the gentlelady from Pennsylvania for questions.
Thank you. I mean, the history of this Department of Education Title IX rule, I'm sorry. Can we move to Ms. Ledger-Fernandez and then
Yeah, without objection.
Yes, thank
Gentlelady's
you.
recognized.
Thank you so very much, my wonderful colleague from Pennsylvania. You know, the thing about this rule is that we know that sex discrimination disproportionately impacts women and LGBTQ plus student athletes. That's just a fact. They get harassed more, they get assaulted more. That's why I applauded the Biden administration's update to the Title IX regulations. Let's all remember, the Trump administration passed regulations making it easier for those who discriminate against and harass student athletes, especially women athletes, especially LGBTQ athletes, to get away with it. They made it easier for those predators to harass and attack our student athletes. This is not surprising, given the fact that a key figure in the Trump administration has to pay $88.3 million in verdicts arising from a sexual assault and subsequent defamation. If the leader of the former administration was found guilty of sexual assault, how could we expect that administration to protect student athletes from sexual assault? So I'm very grateful that the Biden administration adopted a new regulation that honors Title IX, which restores and expands protections for women and LGBTQ student athletes. This regulation recognizes that they are the most at risk for harassment and bullying. Sadly, this legislation to overturn the Biden rule is just another piece of Republicans' attack on women and LGBTQ trans and the most vulnerable student athletes. And with that, I will yield back and thank you very much for coming. But Mr. Scott, is there anything else you would like to add to this?
Yeah, the this rule did not include provisions on athletics. That's still being considered in the department, and that rule will be coming out later. But when you talk about athletics, that is a very complicated situation, but it's not dealt with in this rule.
Yeah, do you want to say something, Ms. Fox?
Well, I do. Respectfully, what my colleague just said is absolutely not true. It does impact on sports. Now, the Biden administration has soft-pedaled what it's doing in sports. They don't want to put anything out big before the election because they know what a brouhaha it's going to be. But the regulation says schools are not allowed to prevent a person from participating in an education program or activity consistent with the person's gender identity. There are exceptions to that general policy, but athletics is not included in the exceptions. So athletics are included in this policy that the Biden administration. They are going to put out a separate rule, as I said earlier, on athletics. But it's, I think, using that proposed rule to mislead the American people in Congress into thinking that athletics aren't affected by the rule this resolution would stop. So we can see through the Biden administration's attempt to mislead, and we have an opportunity to pass this resolution and protect women's sports.
I think both appreciate you bringing this up. Doesn't this get back to the core belief that men and women are biologically different? Would you agree with that?
Yes, sir.
Would you agree with that, Bobby?
Sure.
Do you, either one of you think that men ought to be able to play in women's sports?
I do not. I believe men should not participate in women's sports.
The Olympics, the NCAA, and other athletic leagues have been dealing with that for decades, and I think we can defer to their judgment.
No, but what's your core belief?
Well, if it's women's sports, it ought to be women, but then how you define women, as I said, the Olympics have been dealing with that for decades.
No, but your core belief as an elected representative are biological, are you, should you, let me ask you this.
I would defer to the Olympics and the NCAA and other sports leagues to make that determination. Who plays on what sports?
Yeah, but Bobby, we make the laws up here.
Say again?
We're making the laws up here.
Okay.
I mean, you have to have a core belief in it. And if you think men ought to biological, not identification, do you believe in identification? If you identify as a female, you ought to be able to play in a female sport.
Like I said, the Olympics and NCAA
well,
and others have been dealing with this, and you're asking a question to go through all of their considerations and how you define who can play on which sport.
But Scott, I mean, if you don't want to answer that, but I had.
Well, I don't want to answer yes or no. You've had agencies who've been dealing with this for decades.
But you're against this resolution, aren't you?
I am.
Okay. So that pretty well says that you think there's no difference in a biological man and a biological woman. And to say anything to not support this, I mean, I guess that's your belief. My question a year ago, where one of your, hold on, I'm reclaiming my time, and I'll give you a chance to respond, but my question with one of your colleagues who says, yeah, I think if you identify as a female, that regardless of biological, what you are, then you ought to be able to play. And my next question for him was, would you let your daughter get in the ring with Mike Tyson?
Well, like I said, the Olympics and all the other sports have been dealing with that, and what the discrimination has been defined, or based on account of sex, has been defined by the Supreme Court. Now, I'm aware that a lot of people don't agree with what the Supreme Court did.
Well, we make the laws up here, Mr. Scott, you know that.
That's the Supreme Court.
And just like, can a biological man have a baby? I don't think so. That's not even, I mean, that's not, you know the truth on that. Miss Virginia, you are totally against a biological man, biological, not identifying as a man, should not be able to play. And as far as protecting women, to say that if you believe anything else, the examples that we had, in 2022, North Carolina volleyball player Peyton McNabb suffered a serious injury after a trans-identified male player spiked a ball and rendered her unconscious. How's that fair to women? Last year, a female athlete was injured by a trans-identified male during a hockey game in Massachusetts when a ball he threw at her knocked her front teeth out. Is that protecting women? No, and we just had Riley games in South Carolina, and Ms. Fox, she actually tied she made those seconds up, and the whole, if she'd been a second under, a microsecond under, she wouldn't have been a question. The great part about this, she tied a biological male who, as Riley said, was intact, and who I would also add was having relations with the opposite sex in the changing rooms. To show you how ridiculous this is. But she tied them, and then they wanted, because of the woke philosophy that this administration is taking, they want to give it to the trans female, which is ridiculous. I hope the Democrats keep doing this. The public is sick of this. This is just common sense. And to defer to any other agency, you have a core belief, we make the laws, we make the rules, and you'll be voting on this. And this isn't, with all the problems we've got to even have to do this with the Biden administration, with what their interpretations are. But thank you for doing it. Now yield back.
Gentleman yields back. Chair thanks the gentleman. The gentlelady from Pennsylvania is recognized.
Thank you, and thank you for allowing us to switch order earlier. Look, all students deserve to learn in an environment free from discrimination, sex-based harassment, bullying, and it's critical that our schools have the tools and responsibility to provide that environment. The Department of Education's Title IX rule is critical to ensuring that the department enforces the rights of women, survivors of sexual violence, and LGBTQI+ students. So the rule pushes colleges and universities to better address cases of discrimination and harassment, and it clarifies that Title IX protects LGBTQI+ students with its promise of gender equality. The rule is realistic in that it contains important exceptions and other flexibility that gives schools the leeway necessary to appropriately comply with Title IX, and none of this should be controversial or complicated. Ranking Member Scott, I've just got a couple questions here. We're talking about a CRA, right? So the entire rule would be gutted and the administration could not revisit it for a period of time. Is that right?
Couldn't revisit, the present administration, future administrations couldn't visit it, and you'd be stuck with the 2020 rule.
Okay.
Because you would have eliminated the recent rule, and you're stuck with the 2020 rule.
Okay, so does the Biden administration's Title IX rule strengthen protections for student survivors, making it easier for survivors to report sexual misconduct and prevent schools from ignoring reports of sexual misconduct?
They make several improvements, one of which in the 2020 rule that would go into effect if this were to pass and eliminate the recent rule, says if it happens off campus, the college can ignore it, even though technically off campus, a lot of students are participating in student activities. Off campus, you can just ignore those altogether. The number of employees who have to make reports is limited in the old report. That would be reinstated. The present rule requires you to have timely hearings. You can't just string the thing out. I mean, there are a lot of improvements, and it has an anti-retaliation provision.
Okay, so it clarifies that higher ed institutions can't ignore off-campus problems, and it says that they can't just turf these complaints. Does the rule also ensure that sex discrimination and sexual harassment claims don't have to have higher standards of proof compared to other harassment claims?
The old rule allowed you to have different standards. This says you should have the same standard as others. Okay. So if you're proving sexual harassment, you should have the same based on other factors, race, religion, and whatnot. Okay. You shouldn't have a higher standard for sex.
Okay, and does this rule ensure that pregnant and parenting students have equal educational opportunities and are not discriminated against?
And failure to give them equal opportunity would constitute discrimination.
Okay, so I just wanted to be clear that House Republicans are willing to get rid of this rule, leaving student survivors of sexual assault less protected, leaving pregnant students less protected, and just to target transgender students, presumably. So it really appears to be about bigotry, plain and simple. Trans students exist. They are subject to discrimination. We need to protect them as well. They're not going to be removed from public life, and you shouldn't be supporting things to remove them from our schools. Mr. Chair, I ask unanimous consent to enter into the record a letter signed by dozens of organizations, including women, medical professionals, LGBTQ rights organizations, labor organizations, sports organizations, and others, all opposing HJ Res 165.
Without objection.
Thank you. I yield back.
And the gentlelady yields back, Chair. Thanks, the gentlelady. The gentlelady from Indiana is recognized for questions.
Thank you, Mr. Chairman. Thank you to Dr. Fox, Chairwoman Fox, and the ranking member for coming before the Rules Committee. As a member of the Education and Workforce Committee, I'm certainly happy to have considered this and many other issues this Congress. As you know, the committee did pass the Protection of Women and Girls Sports Act in an effort to protect Title IX, which the Department of Education has failed to do. As a parent of 2 female student athletes, I do have a vested interest in this issue. I had the opportunity to speak with Riley Gaines on her personal experience competing against a biological male, as well as the NCAA allowing Leah Thomas full access to female locker rooms without the female swimmer's consent. And when Secretary Cardona came before our committee to testify, you might remember that I asked him a question requiring women to undress in front of Leah Thomas and allowing Leah to undress in front of them. I asked the Secretary if he believed that constituted sexual harassment, and his answer was yes. I was surprised that he answered it that way, but as the questioning went on, he realized where I was going with that. I said if Leah Thomas identified it as a male, would requiring female swimmers to dress with him have constituted sexual harassment? And he said, yes. So I find it odd that our colleagues on the other side of the aisle are so intent on opposing what we're simply asking, which is to protect the integrity of women's sports for biological women and to protect women from having men in their locker rooms. And as parents of 2 daughters who were swimmers, this is an issue that is something that mothers and parents across the country, unfortunately, are having to deal with, and the Biden administration has just simply doubled down on it. So to Chairwoman Fox, I want to touch a little bit about, there was a recent Supreme Court decision in the Loper-Bright case overturning Chevron deference. Do you think that this rule should be overturned by the courts?
Oh, absolutely. And we already have split decisions on the part of the courts on this issue. And we've got 2 different court cases, and I want to make sure I stay on the right one. But yes, I think that it could be overturned by the courts. And again, we've got court precedent where 2 courts, or one court said, here we go, a split among federal courts. In January of last year, the 11th Circuit held that a school district's policy requiring people to use the bathroom that corresponds with the student's biological sex is allowed under Title IX. In addition, the first 2 court cases that have been handed down in cases challenging this regulation have argued that the regulation's an overreach and an abuse of power. So the argument that with this rule, the Biden administration is simply doing what courts have said must be done when they're talking about Bostock in that case, the opposite is true. The Supreme Court explicitly warned against applying its Bostock ruling to Title IX, but the Biden administration is ignoring that warning.
Chairwoman Fox, do you think Congress intended Title IX to protect the rights of boys to shower with girls?
Absolutely not.
And this action by the Biden administration, does it not invent such a right for more than 50 years after Title IX's enactment? It seems like this is that type of overreach, that it codifies, if you will, that the Biden administration believes that boys do have a right to shower with girls.
I think that's absolutely true. Again, as I said in my earlier comment, Title IX was designed to protect women, give them equal opportunity, and this is wiping it out. And it's really a puzzle to me as to why the Democrat Party has decided to wipe out women.
Mr. Scott, you have made, you received some questions from my colleague, Mr. Norman, and he asked if you believe there are differences between men and women, and you said yes. You do believe there are differences between men and women.
Yes.
Yes. So I just want to ask you, and this is in all seriousness, how do you define a woman? What is a woman?
Well, if you, how do I define a woman?
How would you define a woman?
If you're looking for, you mentioned some court cases, the Bostock.
Well, I didn't ask about,
Two-
I didn't ask about the court cases. Before you get to the court cases, what is a woman?
You have men, you have women. I mean, if you don't know, I can't help you.
Well, I know. It's a biological human female. I was asking if you know.
Well, what's a female?
Well, a female
Okay, well,
is,
in the months following the Bostock decision, 2 appellate courts have reached the same conclusion, citing that case in their holdings that Title IX protects transgender students from discrimination on the basis of gender identity. I think that's the important, if you're talking about court cases, I think that's the important aspect.
is a man that identifies as a female a woman?
I'd say there's transgender.
If a man identifies as a female, is that a woman?
I think it's a transgender woman.
Is it a woman? Is it a biological human female?
I don't know what difference that makes.
Chairwoman Fox, would you care to answer?
I believe that a woman has distinct chromosomes, a man has distinct chromosomes, and that's how you distinguish between a man and a woman. And I think we know what women are and what men are based on their chromosomes.
It's kind of hard to believe that we have to have this conversation in the halls of Congress about what is a woman, and there are differences between men and women, and we do know there are differences between men and women, and we know it is particularly evident in the playing of sports. And Mr. Norman and others have referenced some of the injuries that have happened to female athletes in competing against biological males. So Chairwoman Fox, I just want to thank you for your leadership on this issue and your strong stance to protect women and girls' sports and women and girls in their private spaces. Thank you, and I yield back.
Thank you.
Gentlelady yields back. Chair, thanks. The gentlelady, the ranking member, is recognized.
Yeah,
for
I'll ask some
questions.
questions. I can't believe we're even talking about this stuff, but anyway, I yield back.
Chair, thanks. The gentleman. Gentleman yields back. The gentleman from New York is recognized.
Thank you very much, Mr. Chairman. Dr. Fox, it's always nice to see you. To recap, the resolution before us today is not discriminating against or barring any individual from athletic or other opportunities. Is that correct?
Correct.
Correct. Thank you. This is about protecting access to everything from athletics to intimate spaces to scholarships for biological females. In other words, access to opportunities based on one's biological sex and scientifically proven physiological differences. Would that generally be correct, Dr. Fox?
Yes, sir, and I appreciate your talking about science.
Thank you very much, Chairwoman. As the father of a daughter who participates in youth sports, I am glad to see this resolution before us today. What the Biden administration is doing to undermine access to opportunities for biological women to participate and compete in sports is not only alarming, but it flies entirely in the face of scientific reality. Once again, we're seeing an administration pander to a radical base, and this will be at the cost of access for women and girls to athletic and other opportunities in the future that until recently have been solidly protected under Title IX. And with that, Mr. Chairman, I yield back.
Chair, thanks. The gentleman. Gentleman yields back. The gentleman from Georgia is recognized.
Mr. Chairman, I agree with the ranking member. I can't believe we're actually having to discuss this. Wimbledon's going on right now. They have men's tennis, they have women's tennis, and they have mixed doubles. But I think, you know, just as a father with a 10-year-old little girl and a 6-year-old little boy, they understand the difference. It's kind of embarrassing that the President of the United States doesn't.
Does the gentleman yield back? Chair, thanks. The gentleman yields back. I thank this panel for a thought-provoking discussion, and this panel is excused.
Thank you, Mr.
I know we're up against a vote, but I would like to welcome our fourth panel, Representative Jeff Duncan, Chairman Duncan, Ranking Member Frank Pallone from the Committee on Energy and Commerce.
Mr. Chairman, I have letters to introduce by unanimous consent.
Without objection.
Okay. Thank you.
Being mindful of the new rules on votes and how quickly the gavel will fall as the voting time expires, I did want to start. You are our last panel. So Representative Duncan, Chairman Duncan, we welcome your testimony.
Thank you, Mr. Chairman. I just want to make sure we don't miss votes. I'm very sensitive to the ranking member on that issue, and we had this happen last week in our committee. Just want to make sure that we don't have it happen here. I want to thank you and the ranking member, McGovern, for recognizing me to speak. I'm praying for Texas. Hope your district is not affected by the storm that is ravaging across Texas right now. The bills being considered today will protect Americans from federal mandates and increase costs, fail to result in significant energy savings, and are not practical and eliminate the performance features of product choices. Both H.R. 7637, authored by Representative Miller Meeks, and H.R. 7700, authored by Representative Langworthy, have both gone through regular order. I'm going to skip ahead in the essence of time. The standards put out by the Biden administration are not only increasing the cost, but also decreasing appliance reliability. Homeowners are already spending 34% more on appliances than they did just 15 years ago. From 1995 to 2005, the average homeowner replaced their appliances every 12 to 13 years. Today, that replacement period runs every 8 to 9 years. The Biden administration's Trust to Green agenda is causing Americans to pay more for less reliable appliances. The administration is arguing that these efficiency standards will save consumers money throughout the lifespan of the product, and that's just simply not true. For dishwashers, the DOE's own analysis finds that efficiency mandates could increase upfront costs by 28%. It could take consumers 12 years to pay back the increased cost on a product that may only last 7 to 12 years. Same thing with refrigerators. Time's a little further out. Refrigerators last about 14 to 15 years. It takes about 10 years to pay back the increased cost for refrigerators. Congress must act. Given the recent Supreme Court decision overturning Chevron deference, now more than ever it's important for Congress to legislate clearly. We must prevent the abuse of executive agencies in using statutory interpretation to push political objective, often at the cost to the American people. So in conclusion, Congress is acting today to stop the Biden administration and the DOE from abusing the law and waging war on Americans' cost of living. With the cost of living and cost of everything really increasing as a result of runaway inflation caused by the Biden administration's reckless spending policies, the last thing the DOE should be doing is making home appliances for Americans more expensive. The Biden administration should put affordability and reliability above the interest of radical climate lobby. These bills in front of us today do just that. I urge my colleagues on both sides of the aisle, and I will yield back.
Sure, thanks to the gentleman. Gentleman yields back. The gentleman from New Jersey is recognized.
Thank you, Chairman Burgess. Let me, if I can submit the whole statement and summarize, because again, I don't want us to miss the votes.
We don't want you to read it.
Thank you. I'm not really sure why we're here today. About 2 months ago in early May, the House passed H.R. 6192, the Hands Off Our Home Appliances Act, and I opposed that bill and was before rules on that because it guts the Department of Energy's appliance standards programs for all appliances. But rather than move on the next policy on their list, House Republicans have instead chosen to double back to the same set of tired ideas, this time singling out refrigerator and dishwasher standards. And I think you guys are just running out of things to do because this has been already covered by the other bill. So with regard to these two bills, I guess I could just have played my video statement from 2 months ago on the Hands Off Our Home Appliance Act because these two bills were already covered. but they are bad for the American people. They would lead to higher energy bills for hardworking American families, would increase greenhouse gas pollution, which would further worsen the climate crisis. Now, I want to say that energy conservation standards are popular with Americans. When they were finalized, the way they were finalized on these two issues, the Biden administration is on track to provide nearly $1 trillion in consumer savings over 30 years. That's for the two, the refrigerators and the dishwashers. DOE estimates that its full suite of efficiency standards, once finalized, will result in a reduction of 2.5 billion metric tons of greenhouse gas emissions over 30 years. Now, not only are these things duplicative, but under the existing law, the Energy Policy and Conservation Act, DOE is required to ensure that energy conservation standards are economically justifiable, technologically feasible, and result in significant energy savings. So these bills before us borrow the language from that underlying legislation that's already law, but they actually weaken the standards program, and they're really lack definitions and are intentionally vague. Look, I think that the bottom line is that industry got together, also consumer groups got together, advocates got together, and they all agreed that these standards make sense. So this is not something that's being energy-driven. I don't really understand where you're coming from when the industry itself has no problems with the efficiency standards. I'm going to just, run through this because, again, I don't want to be repetitive given the time that we have here. But at the end of the day, we have two bills that no one is asking for, are duplicative of bills that Republicans just passed on the House floor 2 months ago, and two bills that would increase energy bills for Americans and rob them of savings. So I just don't think there's any reason for you to do this other than you have nothing to do this week. And with that, I yield back.
Mr. Chairman, I request, since I abbreviated my statement, I'd like to submit the whole statement for the record.
Without objection, so ordered. And I want to thank both of our witnesses. I thank you for your succinct summaries of your testimony. As I have been through the hearings and the markups and the subcommittee markup and the full committee markup in Energy and Commerce, I have no questions. I'll yield to the ranking member.
Well, as the ranking member said, we've kind of been here before, and we've had these discussions before, but I again have to point out for the record, I mean, my Republican friends don't believe in freedom for women when it comes to their reproductive rights. They don't believe in freedom for the LGBTQ community, as evidenced by the last bill and every other bill that we bring before the Rules Committee that has anti-LGBTQ riders. But when it comes to freedom for refrigerators and dishwashers, you're all in. So I have nothing more to say. I yield back.
Sure, thanks, the gentleman. The gentleman yields back. The gentleman from New York is recognized.
Since it's my bill, I think I have to talk about this one. Chairman Duncan, under the Biden administration's 2023 notice of proposed rulemaking for dishwasher efficiency standards, they admitted in their analysis that it would take more than 12 years for the proposed efficiency upgrades to break even. Is that correct?
That's correct.
And according to Consumer Reports' own analysis of the lifespan of a dishwasher for the average American home, the usual lifespan, if the appliance is kept in excellent, pristine condition, is 10 years. But more often, much less than that. So under this rule, and based on what anyone who uses appliances regularly would know, most Americans will never see the savings laid out in the proposed rule. Would that be correct, Chairman Duncan?
That's correct.
So just as a reminder for us today, the Energy Policy and Conservation Act requires that any standard imposed by the Department of Energy on appliances, including dishwashers, refrigerators, and others to be cost-effective. Given the timeline to break even laid out under this proposed rule, how could they possibly demonstrate cost-effectiveness here?
They can't.
Yes, thank you. The total savings here for consumers is estimated to be $17 over the entire lifespan of the dishwasher, if that even lasts long enough to break even. Is that accurate, Chairman?
That's correct.
Thank you. I certainly agree, and I think that the American people would agree as well. To my colleagues on the other side of the aisle who believe that pushing back on this administration's regulatory agenda as it relates to basic home appliances is trivial, I'll say this. $17 in efficiency savings on an appliance over a 12-year span is trivial. This is rulemaking and policy at its most ridiculous. I am proud to lead this legislation today alongside H.R. 7637, led by my colleague, Representative Miller Meeks, and I yield back, Mr. Chairman.
Sure, thanks, the gentleman. Gentleman yields back. The gentlelady from Pennsylvania is recognized.
I can't believe that we're here with refrigerator freedom and laundry liberty again. I mean, I thought we'd beaten this horse to death. It does seem after, the 4th of July, we can pledge allegiance to the fridge of the United States of America and to the dishwasher for which it stands, one nation under God, indivisible except for gas stoves, with liberty and justice for all appliances. I think these bills are ridiculous. I think they miss the point of the fact that consumers want energy efficiency standards. It's been something that has been the law of the land for decades. We should continue with it. Mr. Neal, is there anything you wanted to add?
Well, I just wanted to respond to the sponsor if I could. And, I believe he's referencing the wrong rule. With regard to the dishwasher claim that he made, the claim of a 12-year payback period is in reference to a proposed rule in May of '23. But that was not the one that was adopted. They adopted a rule that basically says that the payback period at the standard level is 3.9 years, while the estimated average lifetime of a dishwasher is 15.2 years. And I could provide the same information for refrigerators, but for the sake of time, I will not.
Thank you. I yield back.
Gentlelady yields back. Chair thanks the gentlelady. The gentleman from Georgia is recognized.
I'll allow Mr. Langworthy to respond.
Could the ranking member tell me, give me any recommendations as where I could get a dishwasher the last 15 years? Because I've replaced 2 in a house I've owned for 3 years. So I'd appreciate that, but thank you. I yield back.
I agree this is ridiculous, but I'll tell you what's more ridiculous is that we have Americans that get up every morning and go to work who can hardly pay their own bills, and we're taking their tax money away from them and paying some bureaucrat at the EPA or some other federal agency to come up with this nonsense. Now, I'm going to tell you something. If you're working at a federal agency and you think that this is what you're supposed to be doing, then you shouldn't be there. You just shouldn't be there. So I look forward to voting for it. I think it's total BS that the Biden administration thinks that they should micromanage every aspect of our households, and I can't wait for this to come to an end in November.
Gentleman yields back. Chair thanks of this panel. You're excused. The committee stands in recess, subject to the call of the chair. Very good. Committee will reconvene. I would now like to invite Mr. Moylan to the witness table to be heard on his amendment.
Thank you, Chairman and members of the committee, and thank you for allowing me to testify on my two amendments for the legislative branch appropriation bill. So my first amendment emphasizes the important role of the U.S. Botanic Gardens, plays in what it does and play in educating the visitors about the important value of the plants. And the garden brings America's plants under one roof where visitors can admire a slice of America's natural beauty from sea to shining sea. So currently, however, the garden does not have native plants from Guam. So my amendment underscores the important role that the garden has in promoting conservation efforts. And I would like to highlight one plant. It's known as the fire tree. So today, there's only one mature, naturally occurring fire tree on Guam. And it's located within Camp Blas, our new Marine Corps base being built on Guam. And since 1987, these trees have been listed as endangered by the Fish and Wildlife Services. In May of last year, the destructive path of Typhoon Mawar reached the site of the last native fire tree, and it was damaged. Yet still, the tree survives, and seeds were collected and conserved to conserve the tree for generations to come. So in many ways, the native fire tree is a metaphor for the people of Guam, talking about they're resilient, they're strong, and they're vibrant. And these trees have survived through many turning points in Guam's history, from Magellan landing to the United States taking back possession of Guam in World War II till today. And just in a few weeks, we'll be celebrating our 80th anniversary of the liberation of Guam from World War II. So the Botanic Garden has a unique mission to conserve and study and inspire appreciation for America's plants. So my amendment seeks to strengthen the garden's commitment to this mission, and it would allow the garden to play a role in conserving Guam's natural beauty. So for my second amendment, I would also like to discuss my amendment number 39. This amendment increases and decreases funding for the U.S. Capitol building to allow for including statues from the U.S. territories. Currently, as many already know, there are 100 statues from 50 states. However, there is not a single statue in the Capitol complex that recognizes the territories, our culture, or our people. Guam and the territories are full of patriotic Americans who have fought for our country, served in nearly every level of public service, and have made meaningful and lasting contributions to our nation in several ways. Each territory, just as every state, has a unique symbol of their history. And today, thousands of individuals walk through the Capitol complex. However, while they hear of territorial representation in the House of Representatives, what they don't see is a symbol of the identity of territories within the halls of Congress. This inequity needs to change, and as this amendment, and my amendment, it provides that. I thank you, Mr. Chairman, and the committee. Appreciate it.
Sure, thanks, gentlemen. The gentleman yields back. I have no questions. I'll yield to the ranking member.
Thank you for being here. I have no questions.
The gentlelady from Minnesota is recognized. The gentlelady has no questions. The gentlelady from Pennsylvania is recognized. The gentlelady has no questions. The gentlelady from Indiana is recognized. No questions, and the gentleman from New York is recognized. No questions. The gentleman from Georgia is recognized. Thank you, Mr. Moylan. Thank you for taking time to come up here and share this with us today. We appreciate you being here. Thank you. The witness is excused. Is there anyone else seeking to testify on H.R. 8281, H.R. 8772, H.J. Res. 165, H.R. 7637, or H.R. 7700? Seeing none, this closes the hearing portion. And the chair will be in receipt of a motion from the gentleman from Pennsylvania, Mr. Reschenthaler.
Thank you, Mr. Chairman. I move the committee grant H.R. 8281, the Safeguard American Voter Eligibility Act, a closed rule. The rule waives all points of order against consideration of the bill. The rule provides the amendment in the nature of a substitute recommended by the Committee on House Administration, now printed in the bill, shall be considered as adopted, and the bill as amended shall be considered as read. The rule waives all points of order against provisions in the bill as amended. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on House Administration or their respective designees. The rule provides 1 motion to recommit. The rule further provides for consideration of H.J. Res. 165, providing for congressional disapproval under Chapter 8 of Title 5, the United States Code, of the rule submitted by the Department of Education relating to non-discrimination on the basis of sex in education programs or activities receiving federal financial assistance under a closed rule. The rule waives all points of order against consideration of the joint resolution. The rule provides that the joint resolution shall be considered as read. The rule provides all points of order against provisions of joint resolution. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Education and Workforce or their respective designees. The rule provides 1 motion to recommit. The rule further provides for consideration of H.R. 8772, the Legislative Branch Appropriations Act 2025, under a structured rule. The rule waives all points of order against consideration of the bill. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Appropriation or their respective designees. The rule provides that the bill shall be considered as read. The rule waives all points of order against the provisions in the bill. The rule makes in order only those amendments printed in the report and pro forma amendments described in Section 5. Each amendment shall be considered only in the order printed in the report, may be offered only by a member designated in the report, shall be considered as read, shall be debatable for the time specified in the report, equally divided and controlled by the proponent and an opponent, shall not be subject to an amendment except as provided by Section 5 of the rule, and shall not be subject to a demand for division of the question. All points of order against the amendments printed in the report are waived. The rule provides that the chair and ranking minority member of the Committee on Appropriations or their respective designees may offer up to 10 pro forma amendments, each at any point for the purpose of debate. The rule provides 1 motion to recommit. The rule further provides for consideration of H.R. 7700, the Stop Unaffordable Dishwasher Standards Act, under a closed rule. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce or their respective designees. The rule provides 1 motion to recommit. The rule further provides for consideration of H.R. 7637, the Refrigerator Freedom Act, under a closed rule. The rule waives all points of order against consideration of the bill. The rule provides that the bill shall be considered as read. The rule waives all points of order against provisions in the bill. The rule provides 1 hour of general debate, equally divided and controlled by the chair and ranking minority member of the Committee on Energy and Commerce or their respective designees. Finally, the rule provides 1 motion to recommit.
Thank you very much. You've now heard the motion. Is there any discussion
Yes.
or amendment to the rule?
Yes.
For what purpose the gentleman from Massachusetts seek recognition?
So, Mr. Chair, as I read this document here today, there are 4 completely closed rules. And the 1 structured rule only makes in order Republican amendments. All Democratic amendments were shut out. All bipartisan amendments were shut out. I don't even know where to begin to express our frustration over this process. I'm noticing that that one of the amendments made in order is from Mr. Self of Texas to one of the bills here, and it says it was submitted late. Mr. Morelli had an amendment that was offered in committee on the voter suppression bill that we're going to be considering, and I was told that he offered it late, so it couldn't be made in order. But yet, this Republican amendment is made in order. Mr. Morelli's amendment was around for quite some time, and granted, the committee never asked for people to submit amendments on the voting bill, but he did, and it was late. I just have to tell you, this is 4 closed rules, completely closed rules. And on the 1 structured rule, every Democratic amendment, notwithstanding the fact that a number of them were germane, has been blocked, and all bipartisan amendments are blocked. So this is what my friends consider a fair process. It is anything but fair. It makes a mockery of any attempt to have a deliberative process, and again, we strongly object. I have an amendment to the rule. I move the committee make and order amendment number 1 to H.R. 8281 offered by Representative Morelli, which modernizes and secures voter registration systems and election infrastructure for eligible voters. This bill could potentially, Republican bill, could potentially disenfranchise millions of American citizens. It should not be considered under a closed rule. If you want to vote to disenfranchise people, that's your prerogative to do so. But those who want to find a way not to have that happen ought to be able to have their opportunity to deliver this on the floor. I'm giving my Republican friends an opportunity to reverse course. You have an opportunity to add a germane amendment to be considered on the floor. And I urge a yes vote on this amendment, and I yield back.
Is there any further discussion on the amendment?
Mr. Chair.
The gentlelady from Minnesota is recognized.
Mr. Chair, I just wanted to comment a little bit about what was going on with the amendment process. And these went through committee. So if you talk about transparency and input, that's when the opportunity happens, is there's a committee process that we have. Bills go through committee. The amendment that you're asking about was offered, and I believe we talked about that earlier, and there was one Democrat that voted for it, because none of the other Democrats even bothered to show up to support or vote on the amendment, as I recall the discussion earlier. Because Mr. Morelli offered it in committee. And I think that's where we think that everything should not be done here in rules, and everything should not be done on the floor. The committees have a purpose. The committees discuss bills, hours and hours on end. Amendments are offered. Some pass, some fail. Those are the opportunities that we have to make things happen through the process. Yeah. And so because you're unhappy about one amendment not being included, which is Mr. Morelli's.
I'm unhappy about everything.
Okay, well, then you can be unhappy. I'm sorry that you're unhappy about it. But as we focus on that one amendment, it was offered in committee, and it failed because only one Democrat bothered to show up to talk about it. So
Mr. Chair?
I yield back, Mr. Chair.
Gentlelady yields back.
I would just respond to the gentlelady by saying, are you kidding me? I mean, 4 of these bills are being brought up into completely closed rules. And the one structured rule here only allows Republican amendments, shuts out all Democratic amendments, even those that are germane, and all bipartisan amendments. So please, to try to, and this new rule now, that if an amendment is considered in a committee, that then somehow it shouldn't be considered on the floor. If that's the new rule, then that's news to me, because there are lots of amendments that I remember being brought up by Republicans that were dismissed in the Committee of Jurisdiction that were made in order. And there have been times when Republicans have made amendments in order that did not pass in committee. But to suggest, that it's about one amendment, it's not about just one amendment. I'm mad about this one amendment because I don't want to see millions of voters disenfranchised. But I am outraged that we have 4 closed rules, and the one structured rule, every Democratic amendment and every bipartisan amendment is not made in order. This is not the way this committee should be run. It's not the way the House should be run. People should be ashamed of themselves for voting for this and advancing this to the floor. This is not the way this place should work. And I think all of you know that. And to defend this is stunning to me.
Mr. Chair.
For purposes of the gentleman from Texas seek recognition.
I would just make a couple of observations. First, as a general matter, I do believe we should have more open rules, more structured rules, more amendments on the floor. As a general matter, I do. I think we could be doing a better job this Congress, and I'd hope we would. I had one open rule. If you look at the data, it's not updated through this week, because I don't have these bills added to it. 40% in the 118th are structured, 56% closed. In the 117th, Democrats, 39% structured, 61% closed. In the 116th, Democrats in charge, 46% structured, 54% closed. Republicans, it was 44, 56, and 115. My point is, roughly on par. When you look on this in the aggregate over the course of the year, we'll be able to look at it and see. I do think on average, we should, as whoever's in charge, we ought to do a better job of working to try to increase and open amendments. Not all bills are going to do that. We all recognize that. Not all bills are going to be the kind that we're going to put on the floor and open it up for structured or open rules. I would just suggest that currently it's roughly in line. Roughly in line with what I think over the last 4 Congresses is probably not good enough on average if we were going to offer more amendments on the floor to make sure that more people had a voice in saying that they could amend it. But with that, I just wanted to kind of push back on the notion that there's something completely out of left field about the way this rule is being structured. It's in line with the way Congress has been over the last 4 years. Yield back.
Mr. Chair?
For purposes, the gentleman from Massachusetts seek
So
recognition.
if I understand the gentleman from Texas correctly, he's for a more open process, except when it comes to his bills. Because this is a completely, your bill is being brought up under a completely closed rule. I'm just wondering why the gentleman is afraid of debating the Morelli amendment on the House floor. I mean, if it's germane, it could be debated. I mean, you can give it as little time as you want. And I'm just, but I mean, to give a speech about how, we want more openness, and then consistently vote for like 4 closed rules and a structured rule that makes no Democratic amendments in order, even though many of them were germane, no bipartisan amendments in order, even though some of them were germane, and only a handful of Republican amendments. I don't know, maybe I'm missing something here, but I just don't think that's fair. And especially, it's not living up to the promises that all my friends made when they took control of the House.
Seeing no further discussion,
Mr. Chairman,
for what purpose the gentlelady from New Mexico seek recognition?
I'd like to speak up in favor of my ranking member's amendment.
Recognized.
I think that what we are seeing today shows to the American people exactly why Democrats are so concerned about the upcoming election, because these are the plans that Republicans have for America. When we talk about the threats of Project 2025, it's real. The architects of Project 2025 are the architects of the bill we are seeing today, which would strip American citizens of their ability to register and vote. The architects of Project 2025 would make it harder for military to register and vote. The architects of 2025 will make it harder for women who have gotten married and have changed their name to vote. The architects of 2025 want to depress our democracy, and the inability of Democrats to say, let's have some amendments and have that discussion on the floor is what looks like when you have Republicans who do not believe in bipartisanship. Americans want bipartisanship. They want a debate on these issues, and this committee is shutting off bipartisanship. And for that, I speak in favor of the amendment, and I yield back.
Gentlelady yields back. Chair thanks the gentlelady. Any further discussion? If not, the question is on the amendment from the gentleman from Massachusetts. All those in favor say aye.
Aye.
All those opposed say no. Opinion of the chair, the noes
I
have
ask for
it.
a roll call on that.
Roll call is requested. The clerk will call the roll.
Mr. Reschenthaler? No. Mr. Reschenthaler? No. Mrs. Fishbach? No. Mrs. Fishbach? No. Mr. Massey? Mr. Norman? No. Mr. Norman? No. Mr. Roy? No. Mr. Roy? No. Mrs. Houchin? No. Mrs. Houchin? No. Mr. Langworthy? No. Mr. Langworthy? No. Mr. Scott? No. Mr. Scott? No. Mr. McGovern?
Aye.
Mr. McGovern? Aye. Ms. Scanlon?
Aye.
Ms. Scanlon? Aye. Mr. Neguse? Ms. Leslie-Fernandez? Aye. Ms. Leslie-Fernandez? Aye. Mr. Chairman? Mr. Chairman? No.
The clerk will report the total.
3 yeas, 8 nays.
And the noes have it. The amendment is not agreed to. Other amendment or discussion?
Amendment.
You're recognized on your amendment.
Thank you. I move the committee make an order amendment number 30 to H.R. 8772 offered by Representative Jackson Lee, which strikes Section 212 prohibiting the use of funds for purposes of diversity, equity, and inclusion. This is yet another effort to hobble reasonable attempts to promote diversity, equity, and inclusion. Congress and the people who work here should look like America. We should strive to reflect the rich diversity of our country that makes our nation special. Prohibiting funding for DEI efforts is backwards. It's wrong. I urge a yes vote on my amendment, and I yield back.
Thanks, the gentlelady. Gentlelady yields back. Any further discussion? If not, the question is on the amendment from the gentlelady from Pennsylvania. All those in favor say aye.
Aye.
All those opposed, no.
No.
Opinion of the chair, the noes have it.
Request a recorded vote, please.
Recorded vote has been requested. The clerk will call the roll.
Mr. Reschenthaler? Mr. Reschenthaler? No. Mrs. Fishbach? No. Mrs. Fishbach? No. Mr. Massey? Mr. Norman? No. Mr. Norman? No. Mr. Roy? No. Mr. Roy? No. Mrs. Houchin? No. Mrs. Houchin? No. Mr. Langworthy? No. Mr. Langworthy? No. Mr. Scott? No. Mr. Scott? No. Mr. McGovern?
Aye.
Mr. McGovern? Aye. Ms. Scanlon?
Aye.
Ms. Scanlon? Aye. Mr. Neguse? Ms. Ledger Fernandez? Aye. Ms. Ledger Fernandez? Aye. Mr. Chairman?
Chair votes no.
Mr. Chairman? No.
Clerk will report.
3 yeas, 8 nays.
And the noes have it. The amendment is not agreed to. Any other amendment or discussion?
Mr. Chairman.
Gentlelady from New Mexico.
Mr. Chairman, I have an amendment to the rule. I move the committee make an order amendment number 10 to H.R. 8772, offered by Representative Davids, which strikes Section 213. Section 213, under the guise of religious freedom, creates a license for employees to discriminate against LGBTQ people and prevents the federal government from adequately responding. Once again, Republicans can't seem to help themselves. They took a decent legislative branch appropriations bill and have put in poison pills. They've put rat poison into the legislative process with these. How can they look their colleagues in their eyes when they do this? When they sort of legislate discrimination? The House should have the chance to vote on whether to keep this extreme, radical, and cruel provision. I urge a yes vote on my amendment, and I yield back.
Any further discussion on the amendment? Seeing none, the question is on the amendment from the gentlelady from New Mexico. All those in favor will say aye. Aye. Those opposed, no. No. Opinion of the chair, the noes have it. Recorded vote has been requested. The clerk will call the roll.
Mr. Reschenthaler? Mr. Reschenthaler? No. Mrs. Fishbach? No. Mrs. Fishbach? No. Mr. Massey? Mr. Norman? No. Mr. Norman? No. Mr. Roy? No. Mr. Roy? No. Mrs. Houchin? No. Mrs. Houchin? No. Mr. Langworthy? No. Mr. Langworthy? No. Mr. Scott? No. Mr. Scott? No. Mr. McGovern? Aye. Mr. McGovern? Aye. Ms. Scanlon? Aye. Ms. Scanlon? Aye. Mr. Neguse? Ms. Ledger Fernandez? Aye. Ms. Ledger Fernandez? Aye. Mr. Chairman?
Chair votes no.
Mr. Chairman? No.
Clerk will report the total.
3 yeas, 8 nays.
And the amendment is not agreed to. Further amendment or discussion? Seeing none, the question is then on the motion from the gentleman from Pennsylvania. All those in favor signify by saying aye. Aye. Those opposed, no.
No.
Opinion of the chair, the ayes have it.
We ask for roll call?
Roll call has been requested. The clerk will call the roll.
Mr. Reschenthaler? Aye. Mr. Reschenthaler? Aye. Mrs. Fishbach? Aye. Mrs. Fishbach? Aye. Mr. Massey? Mr. Norman? Aye. Mr. Norman? Aye. Mr. Roy? Aye. Mr. Roy? Aye. Mrs. Houchin? Aye. Mrs. Houchin? Aye. Mr. Langworthy? Aye. Mr. Langworthy? Aye. Mr. Scott? Aye. Mr. Scott? Aye. Mr. McGovern?
No.
Mr. McGovern? No. Ms. Scanlon? No. Ms. Scanlon? No. Mr. Neguse? Ms. Ledger Fernandez?
No.
Ms. Ledger Fernandez? No. Mr. Chairman?
Chair votes aye.
Mr. Chairman? Aye.
Clerk will report.
8 yeas, 3 nays.
And the ayes have it. The motion to report is agreed to. Accordingly, I will be managing this rule for the majority,
And I will manage it for the minority.
and the country awaits. Thank you all. It's been a long day, and I appreciate everyone's attendance. Committee stands adjourned.